Good morning, everyone, and welcome to the District of Columbia Court of Appeals. We have two cases on this morning's regular calendar, and we will get started with the first one, which is numbers 16 CO 1061, 24 CO 254, 24 CO 314. It's Rodney A. Brown and Leonard E. Bishop versus United States.
Good morning, and may it please the court, Maggie Abernathy on behalf of Rodney Brown. I will be arguing for both appellants today, but Mr. Myers would like to reserve 3 minutes in the event this court has questions that relate solely to his client, Leonard Bishop. Beyond that, I would like to reserve 2 minutes for rebuttal. In 2018, Rodney Gordon, having met people who were wrongfully incarcerated, decided to do the right thing and come forward with the truth, that his friend and fellow Alabama Avenue gang member Eugene Nixon was the one responsible for the November 25th shooting, not Rodney or Leonard. From there, the Mid-Atlantic Innocence Project went to 3 other members of the Alabama Avenue gang and confirmed that Eugene Nixon was the shooter. And then later at the IPA hearing, the victim's own best friend, Marcus Johnson, confirmed the motive for that shooting, which was a feud between Alabama Avenue and Roy Tolbert.
I ask you, I hate to interrupt you right off the bat, but I'm curious how this works when the Innocence Project or what's in the record about how it worked here when the Innocence Project finds out that someone has made a statement that's helpful to a client or potential client, then they, how do you know who to go to? You just, how did that work in this case? You just identify witnesses out there and go talk to everybody, or?
I'm not quite sure if that exact answer is in the record. But
I asked just because there are these suggestions of coordination or conspiracy among all the witnesses, but it's important to understand kind of how they arose and, emerged as witnesses for you.
Right. Normally, once you interview one witness, it can lead to other information that you might want to track down, confirm, and verify. And that's essentially what happened in this case. You talk to one witness, they mention other people, you kind of figure out who is involved, who's a part of this gang, the Alabama Avenue gang, and you go talk to them and see if they have other information that can help corroborate what the first witness said.
I see.
And that's essentially what happened here.
Sorry, can you repeat, who was the first witness that the Innocence Project became aware of?
Rodney Gordon. He came forward.
Mr. Gordon, and he contacted the Innocence Project.
He contacted Rodney Brown's initial trial counsel.
Okay.
He knew somebody who was also represented by Mr. Heslop, who was the initial trial counsel, and that's when it kind of got.
Had he contacted Mr. Brown before that?
He attempted to, but he never actually got in touch with him, and so that's when he reached out to Mr. Heslop, and Mr. Heslop eventually brought in the Mid-Atlantic Innocence Project to assist with the case.
Am I right that before that happened, it was 2011 where Mr. Williams said effectively the same thing? That I falsely implicated Brown and Bishop, and I don't remember if he had implicated Nixon at that point.
I don't recall the exact year that Mr. Williams first came forward recanting his trial testimony. He does not say anything about Eugene Nixon. He says that he did not see who the shooters were, so he could not identify them. Mr. Gordon came forward independently on his own later on. So in spite of this evidence, the trial court denied Rodney and Leonard's IPA motion based on finding the witnesses unreliable. But in doing so, it erred in 3 distinct ways. First, it relied on categorical factors without applying them to this particular case. Second, it relied on insignificant differences. And third, it ignored critical evidence. I would like to go through each of these errors in more detail in turn. Starting with that first error, the trial court's use of categorical factors without individualizing them to this case. For example, the trial court relies on the passage of time to say that the witnesses might be misremembering what Nixon told them. But in doing so, the trial court ignored the context of this conversation, which was a confession from one of their close friends and a fellow gang member confessing to a murder that put 2 innocent people in jail that one of them even later joked about.
I didn't really get the sense that Judge Park was concerned about faulty memories, but more about, well, that's a convenient story to come forward with 30 years later, but gee, if it were true, you would have come forward earlier. And now that Mr. Nixon is dead, he's a convenient scapegoat.
took it as three separate reasons for why the trial court was kind of categorically discounting the credibility of these witnesses. One was the passage of time, the length between this conversation and remembering it now, 20 plus years later. Second was the delay in them coming forward. So waiting 20 years rather than coming forward after Nixon died, which was approximately 3 months after Rodney and Leonard's trial. And then the third, blaming it on someone who is deceased. But in each of these situations, the trial court is essentially failing to apply it to this case, and in doing so is erring. So with the passage of time, it's not taking into consideration the content of that conversation and how memorable that conversation would be. With delay, it's not taking into consideration why those witnesses came forward when they came forward. At the time, obviously, they weren't going to come forward. Nixon was their friend. He was their fellow gang member. If they did, they put their own lives at jeopardy. And why would they want to come forward and help Rodney and Leonard, who are a part of this rival group? Doesn't really change the calculus when Nixon dies a couple months later. Those allegiances.
Wait, Rodney and Leonard are part of what rival group?
According to the government at trial, they were part of a group known as the Circle, which is really the area where the crime occurred.
Uh-huh.
So these groups don't really hang out with each other. They're different groups that hang out in different parts of Simple City back in the 90s, and they're not friends, to put it lightly. And by the time Nixon passes away, that doesn't just change miraculously. Those allegiances still exist. They have no reason to come forward and help Rodney and Leonard. And really, it's only because of the passage of time that they want to come forward later. Some distance from the neighborhood, some distance from those rivalries, and perhaps some maturing in there as well. I think Keith Fogel kind of explained it best at the hearing. He was happy to leave that part of his life closed unless someone came forward and finally asked him what happened. All of that is reasonable. All of that is understandable given the context of this case and who we are dealing with. Yet the trial court does not really factor any of that in when it counts delay against these
What about
witnesses.
the argument that these are not, at least the first four, they're not eyewitnesses. They're witnesses to a confession, which, isn't the same as witnessing a crime. And there are a lot of reasons people might falsely confess to something when the confessions are kind of mushy, or, they're not like a handwritten signed confession or something. There are different ways of interpreting it. People might be blustering or, puffing up over or bragging over something they didn't do. The judge did seem to be concerned about that as well. These are not eyewitnesses saying, I saw this and I never told anybody.
I think that's actually why the third error is so important. Failure to really consider the full context of evidence that was offered at the innocence hearing, because I think that really shows the corroboration and the credibility of these witnesses. They're all coming forward. They're saying the same person confessed the same thing. Three of them, the three that were not incarcerated at the time of the shooting, are all relaying a very similar conversation that they had with Eugene Nixon. He sees Roy Tolbert near the circle. He doubles back, he parks, runs up through the cut, an attempted sneak attack, and opens fire at those in the circle. And then beyond that, you have the corroboration of the feud between Alabama Avenue and Roy Tolbert that existed at the time of trial through the expected testimony of Michael Raymond. It exists through the testimony of Keith Fogel and Rob Golden, and also Rodney Gordon statement through his affidavit, and is corroborated by Marcus Johnson, the victim's own best friend in this case, who came forward at the IPA hearing for the first time and corroborated that feud. So when you put it all together, that's what makes these witnesses credible, and that's what makes this confession credible.
So counsel, you just acknowledged though that there are variations in the story. And I guess I'm just wondering sort of what is the role of the Superior Court judge in evaluating these IPA motions? I mean, because he's not supposed to be determining, is there still guilt beyond a reasonable doubt, right? He has two paths available to him. He can say, well, either there's clear and convincing evidence of innocence, or I think by preponderance, there's evidence of innocence, thus, they should get a new trial. And so I'm just wondering, like, how does that impact the judge's credibility assessment, right? Is he supposed to be making sort of a binary credible, not credible, or could be credible, could be incredible. Do you see what I'm saying? Like, I'm struggling with sort of what his job is in assessing credibility of witnesses, because ultimately one of the paths available to him is, well, maybe a jury should hear this again, right? And so, you know, maybe my assessment shouldn't be the final assessment, can you explain that to me?
Right. And I think there are multiple paths that a court could take in assessing the credibility of the witnesses. One could be simply assessing them on demeanor and their mannerisms while testifying, and here that did not happen. The second is looking at the documentary record and other evidence, the witnesses, how they testified.
Have we doctrinally as a court looked at the IPA statute and said, this is how credibility assessments should or shouldn't be made in this context, or?
I don't believe we have, or
Okay.
this court has. It's mainly been reliant on the credibility assessments done by the trial court, but we haven't designated what that means, if it should be sent to the jury to finalize, if there's any doubt, or if it's up to the judge. You know, our position would be that if there is a preponderance standard and it's been met, then that's when it should be sent to the jury for them to consider, or for a new trial for a jury to consider. If the clear and convincing standard has been met, then obviously there would be no new trial, it would just be vacated.
It's just, I mean, in my head, it's sort of tangled up, the meeting that standard is tangled up with these credibility assessments, if you understand what I'm saying. Right? Like, how do you assess that credibility might be impacted by what standard you're thinking you're supposed to be satisfying?
Yes, and I think no matter what standard we choose, we would be successful, for lack of a better term, even if you're looking at what the judge, if it's the judge's position to decide ultimately by preponderance, and not, you know, would a jury find this sufficient to satisfy preponderance? Under either standard, we would be successful
So
because
can
the trial.
Sorry to interrupt, but can we talk about some of the facts that I think that the trial judge thought were more difficult for you? For example, you know, the story that Mr. Nixon wasn't aware that he had not been successful in killing Mr. Tolbert. It doesn't make much sense if the gunman shoots Mr. Newton at point blank range, right? So do you have a response to that?
Well, I think if you look at the full context, you have a better understanding of how that occurs, and that a mistake didn't necessarily need to occur in that instance. What you really have here is a quick event occurring right near sundown, and he runs up through the cut, starts shooting multiple people in the area, hits multiple people that are fleeing with their back to the shooter, comes upon Newton, shoots him. He doesn't necessarily need to mistake Newton for Tolbert, but could have mistaken any of the other number of fleeing individuals as Tolbert, thinking he also got him in the melee. So I think that plausible explanation needed to be considered by the trial court, as this court kind of explained in Stringer. If there are plausible explanations for differences amongst the witnesses, they need to be considered, and sometimes those plausible explanations can make differences insignificant.
What do you do with the fact that most of your witnesses, not all of them, most of them are describing Nixon as a lone gunman, and aside from the identifying witnesses, there are other witnesses on the scene, including the 13-year-old Jones, not the older Jones, who says there's two gunmen. And that doesn't quite jive with Nixon's just driving by, sees Tolbert, jumps out, and goes and commits these shootings. What about that? Why isn't that a serious discrepancy?
Actually disagree that all of the witnesses describe him as a lone gunman. Rodney Gordon says that he sees Eugene Nixon retrieve a gun, or what he presumes to be a gun, get into a car with a second individual, and then head off towards the circle. So Rodney Gordon is insinuating that there is a second person that potentially went and committed this crime with Mr. Nixon. The other individuals simply just don't know who else committed this crime with Mr. Nixon. Now, that could be for any number of reasons of why they're not naming who that person is. Maybe they don't know. Maybe they're not willing to say who that person is. But I don't think there's really any true conflict that there were two shooters and that their story.
Right. So I suppose if they're getting everything secondhand from Nixon, maybe he just doesn't want to identify who he's with.
Right.
Okay.
I go back to a question Judge Easterly asked about the standard, because you say, I think this is in your brief, that at the very least, Brown's and Bishop's innocence is more plausible, as the term that you use, than the government's theory. And you've used the word plausible a lot here when you're talking about the different facts and how the trial judge has rejected them as unreliable or whatever. Is that what we're trying to decide? If you can present a plausible narrative to us, is, you know, that then we have to decide, I guess, is more plausible than the government's narrative at trial, or the government's narrative now and how they're, you know, I don't, is plausibility sort of the key?
I think the way the courts have described the preponderance standard has used that terminology of what is more plausible. Is it more plausible that they are innocent than they are not? And that's really what we have been, what we were using that language for that particular component of the brief. And at the end of the day, you have to look at what the trial evidence was and try and compare what the new evidence of innocence is to that evidence to see if that old evidence really still kind of carries the weight that it did at the time of trial. And so in our view, there is kind of, you look at what is more plausible, the government's theory, and then at the end of the day, if it's not more plausible, does that make Rodney and Leonard more plausibly innocent than?
Can I just,
Sense.
because I have not read all of James Jones's testimony, and I suppose I need to do that. But I got the sense from the trial judge that, you know, here you've got a 61-year-old man who's in the neighborhood. And I get it took him a while to come forward, I think something like 5 months. And I get that later on he's living in one of the detectives, an apartment that detective apparently rents out, which looks weird. I don't really know what to do with it. But kind of what was the attack on James Jones, or what was the cross? What happened at the trial to cast his credibility into any doubt? I mean, he seems like a pretty strong witness.
The main attack on Mr. Jones at trial was this component of him later on finding housing that one of the lead detectives owned at the time. That was a component of it, since he had been trying to leave that area for, I think, 8 years at that point and had not succeeded up until then. So that, again, is very suspicious. And then the other component is just how he acted during the shooting. He testified that he was in the car, heard gunshots. Instead of trying to take cover, he essentially left his car, walked into the line of fire, and then stood and watched. I think a third component was also the discrepancy between him saying that he saw the shooter the entire time, but never saw the shooter walk up and actually point blank shoot the victim, which is not in line with what the medical examiner testified. So those were the various ways that they attacked Mr. Jones's testimony at trial. He did wait, I think, a year. Ms. Jeffries waited around 5 to 6 or 7 months to come forward, so his was a little bit longer, and had no explanation for that delay. So, which is interesting given the trial court is focusing so much on delay with the IPA witnesses, but not looking the same at the trial witnesses who had no explanation whatsoever for waiting the time that they did. So as I mentioned, I think I've gone through most of the errors through the questions, and my time is up. If the court would allow, I would like to briefly touch on the trial evidence and the trial court's weighing of that evidence before sitting. So at the So in addition to the errors made by the trial court in the reliability determinations, it also failed to adequately consider all of the weaknesses in the evidence used to convict Rodney and Leonard at trial. Nowhere in its 50 pages does it mention how long it took for the jury to deliberate. It took over a week, and after deadlocking twice. It does not give proper weight to how incentivized the government's witnesses were in this case. With Keith Williams, he told police on 3 different occasions that he did not see the shooter. He only changes his story after his probation is at risk, and by the time of trial, he's testifying in accordance with a plea deal that's saving him at least 15 years in prison. It does not evaluate how the witnesses contradicted one another, and it does not evaluate how the only reason Rodney and Leonard were arguably even suspects in this case was because Marcus Johnson told a lie to the police after the East Side Club stabbing.
That reminds me of the question that I had for you about that lie. And that's connected to the stabbing that occurs some days after the shooting. Is that right?
Yes, I think it was about a week after the shooting.
And I just got a little bit lost in the narrative. So the shooting, Andre Norton is part of Mr. Tolbert's gang or crew. And so the idea is that the Alabama Avenue people have gone after him. And then the stabbing that happens at the club, the victims there are the two boys. Are they part of the Alabama Avenue crew? I just didn't see, I missed that, if that's the case.
Yes. So essentially, before Andre Newton's death, there's a shooting that involves Roy Tolbert shooting in a car that Michael Raymond is in. Michael
Right.
Raymond is a member of the Alabama Avenue gang and one of Eugene Nixon's close friends. Then in retaliation, the Alabama Avenue gang wants to go after Roy Tolbert. That leads to the shooting in the circle, which leads to Andre Newton's death. In retaliation for that, as Marcus Johnson testified to at the IPA hearing, he goes to the East Side Club and sees members of the Alabama Avenue gang. I think there were about 3 or 4 of them there, and he attacks them and stabs them in retaliation for Newton's death. So that's kind of the trajectory that the world we're working within.
Okay, but so the boys are part of the Alabama Avenue crew, or was it a mistake to think that they were part of the crew and they went after them?
They were part of the crew, and there's testimony at the IPA hearing connecting all of them within the Alabama Avenue gang.
Okay. Thank you.
And Rodney and Leonard are part of a Simple City crew?
They're part of the circle.
Part of the
which-
circle crew,
Right,
okay.
that's what the Simple City is, the broader neighborhood.
Ah.
And then within Simple City, there are different factors, including the Alabama Avenue gang, Roy Tolbert's gang, and then as the government alleged at the trial, the circle.
Was
which was-
Newton killed in the circle?
Yes.
Okay, so so that's just, I wanted to make sure, the government has a pretty plausible theory as to why Leonard and Brown, Leonard and Rodney would have killed Newton. It's because he was stepping on their territory. And I wonder if you have a reaction to, would Alabama Avenue have really felt comfortable stepping on that same territory to go after Tolbert? I don't know. I assume their crews probably were not best friends either, right?
Michael Toland, who was a friend of Rodney and Leonard's and was, I guess, in theory, a part of this circle group. He testified at the IPA hearing that anyone could come in the circle, anyone could sell there. That wasn't really a problem. I think Keith Fogel also said they don't typically go there, but they could go there if they wanted to. You actually see Keith Williams at the time of trial. He's testifying about how initially he went to see his friends at Alabama Avenue, then he goes to the circle. So there is some fluidity, even though they may not consider themselves friends. And ultimately, on top of what what Toland said about the ability to kind of go into these spaces, he also refutes this whole theory of the government for this turf war, saying that nobody asked anyone to move their cars. He wasn't aware the shooting was about to happen. There wasn't this kind of broad conspiracy going on behind the scenes to target Newton for selling in their area. So that was all not really considered by the trial court as well.
Wasn't there some evidence that Newton had money on him, $400 or something? And there was evidence that, or testimony at the trial that whoever shot him went through his pockets and took the money, seemingly looking for drug proceeds, right? Which would cut against this being sort of a revenge killing as opposed to a turf war killing, no?
I would have to check about whether or not there was evidence that he actually had money on him. There was testimony that that his pockets had been gone through by, I think,
Carrington Harley, is that the rest, testified that he had money on him.
sure you're right.
I'm not.
I would
but-
just have to double check. But even if that is true, I don't think it's unreasonable to think that even if it was unrelated to a drug turf war, that someone shooting another person that they know sells drugs would go through their pockets in any event after shooting them. So I don't think it's unreasonable to think that Eugene Nixon could have also gone through his pockets after shooting him as well. that I will reserve any further argument for rebuttal if the court will allow.
We'll give you a few minutes for rebuttal. Mr. Myers, do you have presentation you would like to make?
Very briefly, Your Honor, again, Peter Myers for Mr. Leonard Bishop, may it please the court. And I just want to make 2 points in further response to Judge Easterly's question about how this court should look at the credibility decisions made by the trial judge. This court has indicated that when the judge who's ruling on the subsequent post-trial motion is a different judge than presided over the original trial and is essentially relying upon the same records and transcripts that this court is looking at, this court would give less deference to credibility decisions about the trial testimony. So that's the first point.
When you say less, I'm surprised you'd use that word. Why give any difference? We're reading the same record as the trial judge, right?
Well, I think that's fair.
But have we indicated that we still give deference? I mean, I guess I'll ask Ms. Park that and she'll tell me.
Again, it's certainly, it's a very different posture and perhaps no deference. I mean, this is, again, a question which this court has addressed and said that we certainly don't give the same deference. And perhaps, as Your Honor is saying, no deference should be given in terms of the trial court's credibility determinations of the original trial testimony. And the second point, just briefly, I want to make is that just like the trial judge, Park in this case, and the government's brief, I don't believe there's any substantial difference in the evidence which would require this court to give different consideration to the IPA motions filed by both of these co-defendants. I think they're basically in the same boat.
Mr. Myers, while you're up at the podium, can I just ask you, your client litigated an IRA motion at the same time that he was litigating the IPA motion, is that
Yes,
correct?
that's in the record.
And what was his position about his guilt in the IRA motion?
Again, I want to, to the best of my memory, that again, he was not guilty of the charged offenses. I think that's been Mr. Bishop's consistent position here. Thank you, Your Honor.
Thank you. Hear from the government.
May it please the court, Ann Park on behalf of the United States. After holding a 5-day evidentiary hearing at which appellants presented the testimony of 10 witnesses, Judge Park issued a 51-page order denying the motion. On appeal, appellants primarily contend that Judge Park clearly erred in finding the testimony of 5 of those witnesses and an affidavit of a 6th witness unreliable. In his order, Judge Park explained in detail the evidentiary basis for his refusal to credit these witnesses. Given the deference that is due to a trial court's factual findings, this court has no basis to overturn them. And I'd like to begin with, I think the crux of Judge Park's decision to or determination to not credit the 4 witnesses who testified about the confession that Nixon made was really the disparity or the different accounts of the motive and the intended target. I understand that 4 people came and said the same thing, the general same thing, but the fact that a certain number of witnesses all say A does not make A true. Judge Park had to go look at those stories, compare them with other evidence that he was aware of, and make a credibility determination. And he did that. He explained his reasons thoroughly. It was a permissible view of the evidence. It was a plausible view. And this court, the Supreme Court in Anderson v. Bessemer City has stated, if the trial court's account of the evidence is plausible in light of the review viewed in its entirety, the Court of Appeals may not reverse it, even though convinced that had it been sitting as trier of fact, it would have weighed the evidence differently.
So
Where there are
Ms. Park, I just don't know how plausible I find sort of the point by point refutation of the IPA witnesses in the following sense. 3 of the 4, as I recall, testify broadly that, Mr. Nixon is going after Mr. Tolbert. I think 2 of them specifically say he's particularly upset about the Raymond shooting. The inconsistencies in their testimonies strike me as, impossibly minor, and the types of things that, maybe Nixon told them slightly different stories. The types of details that could get murky over 30 years in a way that he confessed to a murder is likely not to. So, I mean, I get the sense that Judge Park is looking for reasons to discredit each of them, rather than saying, well, wait a minute, all four of these people are coming forward to say that it was Nixon and they've got no real affiliation with each other. Some of them are friends with Nixon. Why would they be making it up? And he kind of ignores that question and instead goes straight to trying to find a reason not to credit each of them.
Disagree. I know generally we have Wanson's, which is completely out in left field,
He says that he intended to kill Newton, right?
like he was targeting Newton because
True.
of some dispute over his ex or his girlfriend. So that's a dispute over women. That's completely different from the three others. The three others are general beef between Alabama Avenue and Tolbert. But Rodney Golden's testimony is very different. He says after a shooting that occurred with Raymond at the hospital, we were all mad. We got together. It was him, Nixon, another man named Chris, and Gordon, whose affidavit we have. We all agreed. We had a conspiracy. We had an agreement that when we saw, whoever saw Tolbert, we're going to kill him or his friends. That is very different from a general beef. And you have that, and then you have Gordon's affidavit, which does not mention a conspiracy whatsoever. Gordon says,
Sorry, I thought you started with Gordon. Who did you start with?
Galden.
Galden, got it. Okay.
Galden testified at the hearing.
Right.
And especially with regard to Galden,
Oh, Galden was the one who there was actually sort of a demeanor basis to.
there was demeanor basis. He had convictions for conspiracy to obstruct justice. There are a whole, if you look at the factual findings for Galden, they are more extensive than the other witnesses. And I would say with Galden, that is a very, very different motive. And Gordon, who is supposedly, allegedly part of this conspiracy and best friends with Nixon, doesn't mention it in his affidavit whatsoever. He does talk about a beef, but it's more of a general beef. And he talks about how they got over it. They were disputing over a craps game, and then there was a shooting, and this was in retaliation for that. So I don't think, if you look at the details, that there is a cohesiveness to their story, even with the three witnesses that are talking about this dispute between Tolbert and Nixon. And I
Hey, why isn't the easy reconciliation? That's the same story. It's just that Gordon doesn't want to implicate himself in a conspiracy to commit murder. Like Gordon left out the part that he was part of the agreement. I mean, that's just very easy to shrug off. Yeah, that's the type of thing you would probably want to leave out of your story.
and you start shrugging everything off. I mean,
I'm not trying to.
Your Honor, to me, it sounds like you're coming from the opposite direction.
I'm coming from the explain to me why four people all say it's Nixon, including, you know, a 13-year-old boy who's on the scene. People that don't seem to have any. There's no sort of. I did not see that there's evidence that they're colluding. They were approached separately after Gordon originally came forward, and they all kind of come forward with the same story without really any opportunity to kind of convene and come up with a story. So it's not, I don't think it's slanted to say, like, what explanation is there for that, rather than sort of putting all their stories under the microscope and looking for some inconsistency. Like, just give me the broad theory as to how that came to pass.
Well, Your Honor, I think you have to look at the details. I mean, otherwise you're basically saying if enough people come up at the same time and you can't prove collusion, you show innocence. But I mean, the point of the
Not
judge
so
is to have a
innocent,
hearing.
right? I mean, again, to be precise under the statute, there are two options. One is to say there's clear and convincing evidence of innocence, and another to say, well, we think there's, you know, evidence of innocence by a preponderance, so let's send this back to a jury,
Yeah.
right?
Yeah.
And so the judge won't be the ultimate arbiter of guilt or innocence, but we'll give them another shot because now there are these new people coming forward who have new information to provide. So
Yes, I'm sorry, I was speaking loosely.
I get it, but I just.
What I was trying to address Judge Deal's point that, look, Judge Park did not rely on any, he didn't make any finding as to the fact that there was collusion or wasn't collusion. What he did was he heard the testimony, he read all the documentary evidence, all the affidavits, and he looked to see whether he thought that these were credible based on his review of the consistencies, the differences in the entire trial. What he came up with, his view, his determination that he didn't really buy these stories, was a plausible and a permissible view of the evidence in light of the entire record that he said he reviewed, and there's evidence in his order that he went through all of it. At this point, Your Honor's job is to say, was it clearly erroneous? There is a permissible view of the evidence.
Well,
We may not agree with it, but we have to affirm it.
That,
That's my
that
understanding.
gets back to my question that I asked counsel for the Innocence Project earlier, sort of what is our actual assessment, right? Because if you think about it and you think, oh, okay, well, if we think that there's evidence by preponderance that this person is innocent, so we're giving them a new trial, that's a weird thing, right? Because, well, just hear me out. I mean, and then you can tell me why I'm thinking about this the wrong way. If a judge is saying, well, there's actually 51% evidence of innocence, then how could there be evidence beyond a reasonable doubt of guilt? And yet the 51% evidence of innocence in the judge's mind gets you that trial where you can say they haven't, right? It almost seems like a useless exercise if the judge has already said 51% evidence of guilt. So maybe what the judge is doing is something else, right? Like they're not doing this sort of definitive, well, I've figured out that this person is or isn't credible, right? They're just doing some sort of pressure testing. And here, where you have multiple witnesses coming forward, and yes, they're giving different stories in the particulars, but the overarching story is this other person did it. And we don't necessarily know each other. We don't necessarily know Brown or Bishop. We've come forward at different times in different ways. There doesn't seem to be an evidence of an obstruction of justice or conspiracy to obstruct justice. Why wouldn't that be enough to say, we need to do this again?
Your Honor, I think
But I'm obscuring, I guess my first question is, am I wrong on the law about how, because
Yes.
you were saying, no, court, you need to, just look and say, is this clear error? And I'm questioning, actually, is there sort of some legal assessment of credibility that's a little bit different than what we would do maybe in a direct appeal?
No, Your Honor. I would say a credibility determination should be reviewed the same way, whether it's trial, a bench trial, a factual finding hearing, a suppression hearing, or IPA, I mean, a credibility determination is a credibility determination. It's reviewed as a fact for or clear error. And I think I understand Your Honor's point. And the factual finding and the standard for clear error is completely separate from the preponderance evidence at the end of the fact findings. So Judge Park, in this case, he went through all the evidence that was presented, whether he thought was new or not new. He credited some, he gave little weight to others. He does all that. He looks at the range of the evidence, the trial evidence as well. He looked at the transcripts and he looked through all that. And then he goes and he has to weigh it. And he has to figure out, well, is there enough evidence of innocence by 51%, by preponderance, to give Mr. Brown and Mr. Bishop a new trial? I think the fact finding has to be done first. And I think Kasten talks about this a little bit. When the judge there was talking about if 4 people come up and say someone's innocent and the judge discounts all 4,
Can I just?
Can I just?
Yeah, yes, please, sure.
She said, Judge Thompson says, and the judge discounts all 4. It's not, the fact that all 4 of them may have said the same thing doesn't make it any more credible. 0 times 4 is 0. He's discredited it. You have to look at whether that factual finding is clearly erroneous or not. And then you look at the weighing of the evidence. That's my understanding
Okay,
of what should happen.
Can I jump in? I don't know what aspect of these witnesses' statements Judge Park is discrediting. So let me see if I can help me figure it out. Mr. Gordon. No, Mr. Nixon did not confess to you. I discredit that. Do you think that's the finding? Or does he just say, I mean, so far as I can tell, the judge never says one thing about these confessions to these various witnesses did not happen. Thereby, so that, right? The judge didn't say that.
He says he finds them unreliable and then goes and.
Right. But it's not, I don't believe he confessed to you. It's okay, he confessed to you, but here's why I think Nixon, I don't think that means he did it. Is that right? I mean, that doesn't sound like a credibility determination to me. It sounds like he's saying, okay, he confessed, he confessed, he confessed. Not good enough. The confessions don't line up in their details. And that doesn't feel like a credibility determination.
I think when he says unreliable, I think that is a credibility determination. It's basically saying, I don't believe what he said.
Who's the he?
Judge Park.
No, who's the he that he doesn't believe? The witnesses or Nixon?
He says for all four of these witnesses, he.
See, it's funny because he never really goes into the, I don't think Nixon told you that. He kind of instead says the story you're relaying from Nixon doesn't line up with the story they're relaying from Nixon. I don't see these confessions never happened kind of finding. I see it all doesn't quite add up because the details of these confessions don't perfectly align.
The effect of it is the same. I mean, he's not going to give credence to their confessions, whether it's complete. I think you're making it up, you're lying. I don't think he has enough evidence to say that they colluded and they're all fabricating this story.
But that gets
I mean, he's
back
never
to
going to,
sort of-
be able to get
That gets
that.
back to my question about what is his job, right? What is his role? And I
The
think
fact finder. And determining credibility and
well, but
determining
he's
how much
the
weight
fact-
to give to the
he's the fact
evidence.
finder to what degree and to what end, right? And you know, yes, he makes credibility determinations, but if he can't even say, I don't think that this is true, you know, I mean, we often get judges who say, you know, I credit this witness, and the witness has said a number of things, some of which conflict and some of which are not possible. And so those kinds of blanket credibility determinations are by and large worthless. And this seems to be of the same cloth of, you know, I just
His
don't think
credibility
this is.
determinations are worthless. He's the only
Well,
person who saw those witnesses.
Sorry. Let me just finish. He's just sort of vaguely saying like, I don't buy it. But it really is on him to tell us what is it he's not crediting. And we don't know.
Your Honors, at this point, it's appellant's burden to show a preponderance of the evidence that the new evidence shows that actual innocence of the defendant, whether by preponderance or clear and convincing. I don't think Judge Park has to figure out the truth. He just has to look at the evidence and say, do I credit it? Am I going to give it weight to it?
You don't
in this
think Judge
analysis?
Park has to figure out the truth? I thought that's what fact finding was, right? Like, I think I've got a witness who's saying X, there's another witness saying
But-
Y. I credit this witness on this point and I credit the other witness on this other point, right? That is fact finding. And too often we don't see actual fact finding here. We just see this witness said this, and then this witness said this, and I credit these two witnesses and their testimony doesn't actually align. And this seems to be,
It's the job of the fact finder.
I agree.
I mean, that
And I
it
don't,
doesn't align and they have
I'm
to
wondering
decide.
whether the problem here is that there wasn't actual, you know, reliable fact finding or reliable credibility assessments that we can really hang our hat on.
Your Honor, he wrote his reasons for why. So I don't understand what the court wants from trial judges in trial courts. Are there talismanic words he has to say? He says, I've heard their testimony. I read their affidavits. Here are the problems I find with their testimony. Here's why I don't credit them or find them unreliable. So I'm not going to put much weight on them. If it's not a complete discrediting, it's at least saying, I can't rely on this to make a finding of actual innocence because it's not believable enough to me.
Ms. Park, can you explain more about, I was interested in your bifurcation of the fact finding with the weighing, and how does that interact with some of our case law, like Stringer, for example? Can you explain, you know, where Stringer, where we actually looked, you might say I don't know whether you think what happened in Stringer was like a clear error kind of finding, but we're really saying we disagree with the trial courts, you know, what the trial court said about the significance of certain facts or the or the disregard of the plausibility of certain other explanations. But how does that fit into your bifurcated way of looking at this?
Stringer was looking at whether the inconsistencies that the judge identified there were significant. And in Caston, this court said that's actually a question of law, whether it's significant inconsistency or an insignificant one. That's a question of law. And so we're going to send it back and you got to rework the evidence.
And would that apply to our, like, take the different motives or the point about how, you know, how Nixon couldn't possibly not know if he killed Tolbert, is that the person?
Yes.
Because of the, you know, the close range shooting. You know, can we, under Caston and Stringer, make the same determination?
I would say no, because here the government's argument is Caston, the just inconsistencies were that the witness said in the affidavit 10 to 12 a.m. to 12 p.m. and he testified at the IP hearing that it happened at night. And then there was testimony that, or his affidavit said one thing about he saw a group of men come out of the carryout, and then he testified there might probably have been a girl, and the judge latched on to those inconsistencies. And this court said, we don't think those are significant, and we think the trial court put too much weight on that. So we're going to send it back. And in Caston, they said the judge didn't even talk about all the other evidence and the relationship between the IPA evidence and the weaknesses specifically in the government's trial evidence. And they sent it back for the trial court to review. That's very different. What the government is saying here is the inconsistencies that Judge Park relied on, the motives, that the intended target, 3 of them say this, and one of them says why. It's like none of the basic parts of the confession line up, and those are
Why is,
significant.
again, I still don't totally understand why that's, why couldn't it be both? You know, I thought I killed.
Bert, and then he wanted to kill Newton over.
He shot multiple people. Yeah, I was going after Tolbert the same way I told those 3 people. And Newton was in my way too, and I didn't like him much because he was with my girlfriend. I mean, so they're not inconsistent. I mean,
Seems rather speculative. You're just taking all these different stories and making a narrative, but I don't think that's what Judge Park is saying. These people are saying someone else did it. I'm looking at the confessions. They're all over the map. I can't hang my hat on this and find evidence. I can't find that this new evidence shows innocence, because I don't believe these stories. I mean, how much he doesn't believe them, or, you know, I don't think that's necessarily important. He doesn't believe them. He's not going to give weight to them. And that's his prerogative as a fact finder after listening to their testimony.
and remind me why he doesn't give weight to the 13-year-old Jones on the scene. Is it just because it wasn't new evidence? Because he thought Brown and Bishop could have found that earlier? Because I mean, that's
No.
okay. Remind me then.
He basically said, Jones testified that he saw it about 20 feet away. It lasted, I think the record said, a minute to a minute and a half. He saw this 30 years later. I mean, he saw this 30 years ago.
But immediately after, he said it wasn't Brown and Bishop, right? That there was people backing him up on that.
Well, he said he told Juan Green, but no one testified. They couldn't find Juan Green or his cousins. He said he did tell his cousins that it wasn't Brown and Bishop, and Green was supposed to tell Brown, and that's the new evidence part of it. But he did say it and testify to it, but there was nothing corroborating it. No one else testified to say, yes, Tyrone Jones told me this 20 years ago. He had never given a prior description of the shooter. And the photo identification, it wasn't really an identification in a typical sense, but he was shown a photo 3 days before the hearing. This is, I don't know, 20, 30 years after the incident. And he says he testified he instantly picked out the photo of Eugene Nixon. And the judge is like, that's not reliable. I'm not going to give you that much weight to this testimony.
I thought part of it was, you know, he also said he was a few feet from the shooting, and then later clarified that it was from about where the judge was to the well, which is really more like 20 feet. Which struck me as a really ridiculous thing to point out, as if that were some kind of inconsistency. I would describe us as a few feet away. I think colloquially, if I took out a tape measure, I suspect 15 feet, I guess. But it kind of bespoke a general tendency of Judge Park to like anything. He would latch on to anything to say, oh, you said a few feet, but actually he was kind of lying because it was 20 feet, and that was ridiculous. And there was a lot of that.
Then Jones testified that he said he knew Brown and Bishop. But there was a huge age gap, so wasn't friends with them. His cousins were good friends with them, and he saw them 5 to 7 times. Brown 5 to 7 times, and
Right.
Bishop 3. So all that together. And I think the fact is he's testifying now for the first time about an incident that happened 30 years ago. And he's saying that he knows for sure it's not Brown and Bishop, and he didn't even know them that well. He says he told someone, but that person they can't find, although they talked to him twice before. All this, and then the whole photo identification where he says he can remember this face 30 years later. 30 years later, Your Honor. I mean, that's one
I
of the
mean,
big
I've never witnessed a murder. I suspect I have a view about
If he
how
was
likely it would be
the
to remember a
person
face.
and he was in the car. I mean, but I think the point is, was it impermissible for Judge Park to view that evidence as unreliable? No. Is it something maybe you would not have? Yes, but at this point, the factual finding is clear error. And this court and the Supreme Court has delineated what the rules are for that. And I think we have to look at the factual findings first and then look at, preponderance and how the judge weighed it. That's my understanding of how the fact-finding, weighing, decision-making process works. And I just wanted to, I've been meaning to say this a couple of times, but I keep getting waylaid. It's not like there were 4 independent witnesses who came together. There's certainly no evidence that there's collusion, but there are relationships between all the parties. So all 4 of the men were close friends with Nixon, and they were close friends with each other. They were part of the gang. Michael Wanson actually testified that he knew Brown and Bishop, and he was friends with Brown and Bishop in 1994. Johnson also, who's part of the Tolbert gang, he knew Brown and Bishop from the neighborhood, and he said he grew up with them. He said he didn't hang out with them, but he was cool with them back then, and he considered them friends. So all these people grew up in the same neighborhood. They knew each other. They knew probably each other's families. There is some evidence that Galden and Wanson were actually cellmates before. And then we do know that Tyrone Jones, his cousin Dion Hunt, and Rodney Brown were at Big Sandy, Kentucky together. I'm not suggesting in the lease, and Judge Park did not find in the lease that there was some sort of collusion or getting the story straight. All I'm just trying to suggest is this isn't a case where you have 4 people who are completely unrelated, all coming and saying the same thing. That didn't happen here. These people knew each other. They knew how to get in touch with each other. They knew about what happened at that point in time. The opinion had come out. You can read about what the facts are. I mean, all that, I just want to point out, not so much for just atmospherics, mainly. If there are no further questions, we'd ask that the judgment of the Superior Court be affirmed.
Ms. Park. Abernathy, we'll give you 3 minutes on rebuttal.
Thank you. The government spends a lot of time talking about deference to the trial court, but deference is not necessary or even required, appropriate when the proper analysis is not done. And that's what happened here. As this court has noted time and time again, there were numerous pieces of evidence that weren't being considered by the trial court. The trial court's findings are not clear on what it is crediting and what it is not crediting. And at bottom here, we have 4 different witnesses saying that Eugene Nixon was the shooter. No evidence of collaboration, and frankly, no opportunity to collaborate. All of these witnesses were incarcerated when they were approached by an investigator from the Mid-Atlantic Innocence Project, effectively scattered across the United States. They were all, most of them, surprised to even be receiving a visit from an investigator. And then on top of that, you have Marcus Johnson, the victim's best friend, someone who clearly has no reason to lie for Rodney and Leonard, coming forward at the IPA hearing and on cross-exam by the government for the first time, confirming that there was this feud between Alabama Avenue and Roy Tolbert. And then, as Your Honor's already mentioned, you have Tyrone Jones, who says for the first time, yeah, actually, that guy resembles the shooter when he's talking about Eugene Nixon, despite not knowing Eugene Nixon had any relevance to this case. That doesn't just happen because some people are that doesn't happen unless people are telling the truth, essentially. And that has to mean something. And the trial court does not address it. It does not focus on that.
So is it more like a Stringer situation where it should be remanded to have the trial judge sort that out?
I think that is one option this court could take, but I also think that the record evidence as it stands now would allow the court to grant further relief, including a new trial or even vacating with prejudice. So there are multiple avenues this court could take, but we think the record as it stands gives this court enough.
You really think it rises to the level of clear and convincing evidence?
I do. If you believe these witnesses, which we think there is more than ample evidence in the record to believe them, then Rodney and Leonard did not commit this shooting. That is clear and convincing evidence that they are innocent of this crime.
That's not totally true, though. Remember, one hypothetical you got was, people, especially when turf battles are involved and people are gang members, there's reason to bluster. There's reason to up your body count. Yeah, I took out Newton. I was going for Tolbert, but so most of these witnesses are ear witnesses to a supposed confession from Nixon, not eyewitnesses. So you could believe them. I believe you that Nixon confessed to you. Nixon's full of hot air, right?
That's why it's important to consider the full context, how these stories fit within the historical record, including this feud between Alabama Avenue. That's what makes them even more credible and their story even more credible. And as each of the witnesses testified at the IPA hearing, they saw no reason for Nixon to be lying to them about this particular shooting. So we really think that there's enough there on its own to establish clear and convincing, at the very least enough to establish preponderance, and then even lower at the very least for a remand for the court to reconsider its findings.
Can I ask one factual question that I don't have a sense of? There's reference in the brief to 13-year-old Jones identifying Nixon cold. That was a couple days before the IPA hearing. Am I right about that? And it was a photo that had 3 people in it. I don't know if this was in evidence. I haven't seen this photo. Is Nixon the most prominent of the 3? Are there 3 distinct people and he picks Nixon from, just it was a 1 in 3 chance if he would pick him, or it was a sort of like is this guy the shooter? And then he said yes.
What we know from the record was that 3 different photographs of 3 different people were shown to Mr. Jones in the days leading up to the hearing, and that he instantly pointed to the photograph of Mr. Nixon and said, that looks like the shooter. At the hearing, he further testified that he did not know who Eugene Nixon was,
Okay.
did not know him before, and had no idea that he was relevant to the proceedings.
So I'll verify, but just to get your answer so that I understand it. 3 different photographs. Do you know which one went to him first? Was Nixon the first one he saw?
That's not the record.
That's not in the record? Okay, but you think 3 distinct photographs, not a photograph of 3 people as I had been thinking. 3 distinct photographs. He says yes to Nixon, says nothing about the other 2? Doesn't look like him?
My
Could have been
understanding of
them?
the record is that it's just he points instantly to Mr. Nixon and said that resembles the shooter.
Okay.
And one clarification I wanted to quickly make before moving on to my final point is that there is actually no evidence in the record that Michael Watson and Rob Golden were ever cellmates leading up to the IPA hearing. The evidence in the record, as we described in footnote 11, which the trial court and the government have not clarified or responded to, is that prior to the innocence hearing, both of them were incarcerated at separate facilities. They were cellmates in Warsaw, Virginia, which is the facility they were brought to in order to testify at the IPA hearing. At the times that the affidavits were signed, which were years before, Mr. Golden was incarcerated in Hazleton, Mr. Watson was incarcerated in Lewisburg, and Mr. Fogel was incarcerated at the Piedmont Regional Jail. So again, they were all scattered and separated to different facilities. No opportunity to collaborate as far as the record shows, and all surprised to be receiving a visit from an investigator. And I want to quickly just touch on the Stringer component that Judge Beckwith brought up on the government's questioning. The problem there is that the plausible explanations that we have offered to this court were not considered by the trial court. And those are all plausible explanations that should have been considered. And Stringer says that. Yes, Castone, some of those differences might have been more minor, but Stringer really builds on that. Stringer expands on that and says you have to consider these plausible explanations that could make these differences less significant. And that's what's happening here. With the motive, they're all speculating. Nobody is saying that Nixon actually told him why he committed this crime. And let's keep in mind, Michael Watson at the time is incarcerated. He's talking to Nixon over the phone in coded language. He's not getting the same kind of information that the other witnesses are. And those other witnesses are all saying the same conversation. Sees Tolbert near the circle, doubles back, parks, thinks he got Nixon. Tolbert finds out later he doesn't get him. That's not inconsistent. That's consistent. As far as the mistaken component, as we've already offered, the plausible explanation there is that he doesn't actually mistake Newton for Tolbert. He mistakes one of the other individuals that he shot for Tolbert and just happens to see Newton, who he wants to hurt anyways because of this separate grudge, and shoots him in the moment, and later tells
It's a little bit of a feel of, asking us to accept or the trial judge to accept any innocent explanation. Is that what you mean?
No, I think it has to be plausible. It has to fit within the record. And here this all makes sense, especially the shooting aspect of it. As Marcus Johnson testified at the IPA hearing, this is how the shootings were done. They would emerge from the cuts and they would blindly start shooting. So they weren't necessarily, taking aim at a lone target and trying to get that one person. They were just firing as they may. So it fits within that record, and it's extremely likely that that's what happened in this particular case. So I think, again, the important thing to remember is that the trial court is not doing the proper analysis. It's not considering all of the critical evidence that speaks to innocence. It's focusing on insignificant differences, and then it's applying these categorical factors without really thinking about how they apply in this particular case. And when that analysis is done and it's not done correctly, then deference is not owed. So we would ask that this court, at the very least, remand for further factual findings, but believe that you are capable of at least reaching the preponderance and clear and convincing standard as well.
Thank you. Mr. Myers, do you have anything you want to say? Or, okay. Okay. Thank you all for your briefing and your arguments in this case. And the case will be submitted. Second case on this morning's calendar is number 25 AA 250 and 25 AA 310. Office of the People's Counsel of the District of Columbia versus DC Public Service Commission and Apartment and Office Building Association of Metropolitan Washington versus DC Public Service Commission. Whenever you're ready, counsel. Feel free to get settled.
May it please the court, my name is Jason Gray from the law firm of Duncan and Allen LLP, and I am appearing today on behalf of both petitioners, the Office of the People's Counsel and the Apartment and Office Building of Metropolitan Washington. I would like to reserve a total of 6 minutes for rebuttal, 3 for the discrete issues that AOBA has raised, and 3 for the due process issues. The challenged orders in this proceeding are the result of regulatory fiat because the commission relied on an incomplete evidentiary record to approve an experimental alternative form of regulation and also subject the district's ratepayers to the largest rate increase that the PSC has ever approved, $123.4 million between 2025 and 2026. The evidentiary record was incomplete because the commission deprived OPC and AOBA of their statutory rights to an evidentiary hearing under section 2-509B of the DC code. That means that the evidentiary record did not contain any documentary or rebuttal evidence that OPC and AOBA had a right to provide at an evidentiary hearing in this contested case. And also it did not include any transcript of cross-examination where OPC or AOBA were able to scrutinize the PEPCO witnesses as to the basis for the rate proposals, the details of the rate proposals at issue, the rationale supporting the investments and the expenses behind the multi-year rate plan, the alternative form of regulation, or just the transition from traditional regulation to an alternative form of regulation itself. In addition to the fact that the evidentiary record was incomplete, there's an independent error that warrants reversal. That is that the commission and the challenge orders identified for the very first time the materials that it deemed to constitute the evidentiary record, and it ruled on the evidentiary record in that same order. As a result, it denied both OPC and AOBA of any opportunity to address the evidence because they did not have prior notice of what the evidence would be.
So counsel, I mean, just can you clarify for me, right? My understanding is that, you and AOBA or OPC and AOBA move for summary judgment, that's denied. Then the commission says, we're going to have a hearing, but it's going to be what they're calling a legislative hearing, which just sounds like oral argument versus an evidentiary hearing. Their pre-hearing briefs and testimony and exhibits are submitted. I don't know where the testimony comes from, but materials are submitted before the legislative hearing. The hearing is held, and then there's post-hearing briefing. And so I guess my question is sort of two parts of, given that process, how is it that you didn't know what was being considered? Because it seemed like it was all out there, and why wasn't this process adequate?
So the process you laid out is for the most part accurate. What I would clarify is the legislative style hearing, which is what the commission called it, was neither legislative style nor hearing. It was an oral argument, as you indicated. The only party representatives
Is there such a thing as a legislative? I mean, let me just back up and say, we hear hundreds of cases a year, many hundreds of cases a year. And I went back and I looked, and I think we've heard 2 Public Service Commission cases in the past 3 years. So this is not our area of expertise. So, when you throw around terms about legislative hearing, please don't assume that we know. And also, to the extent I'll just throw in gratuitously, you can avoid using acronyms. I forgot to ask my law clerks to make cue cards to tell me what they mean. So I will follow along a lot faster or easier if you don't bog down in acronyms.
Sure.
But I mean, there's such a thing as a legislative hearing, like that's like something else.
I share your confusion on that. And in its post-legislative style hearing brief, OPC asked, what is the purpose of this hearing? Will witnesses be allowed to participate? Will evidence be admitted? Will evidence be discussed? Is it an oral argument? We don't really know what a legislative style hearing is, other than we know it's not an evidentiary hearing. And I don't think there's any dispute there. The commission made clear it's not an evidentiary hearing.
Okay,
So-
so, but back to my question.
Yes.
Of, there was this process where evidence was identified, argument was had, post-argument briefing was conducted. So how is it that you didn't know what the evidence was, or the materials, I should say, if we're not going to call it evidence, the materials that were under consideration, what they were, and why wasn't this process sufficient to duke it out over those materials?
Sure. So setting aside the first issue that we have, which is the record was incomplete because no evidentiary hearing, no cross-examination, just turning to the materials that existed. The disagreement I have with the description you provided is there was no evidence at that time. There was no evidentiary record. The commission identified the evidence, what it deemed the evidentiary record to be, in its November order on the merits. Now, in commission
I
proceedings.
guess I'm still sort of struggling, right? Okay, let's call it materials, right?
Yes.
They put forward materials, you put forward materials, maybe you say those materials by, them shouldn't be considered, right? The Pepco's materials you shouldn't disregard those materials, look at our materials. It seems like there was the opportunity to have that type of debate. And so am I missing something?
No, You're precisely correct. So in commission proceedings, there's pre-filed testimony and exhibits. Most of the cases pre-filed, and then an evidentiary hearing, the cross-examination is on what has been pre-filed. So there was a body of materials that was comprised of the pre-filed testimony of all parties, the pre-filed exhibits that those witnesses attached to their testimony, the supporting analyses, and then responses to data requests. None of that was admitted into the record until November, but we knew what it was. And the problem was both OPC and AOBA argued in their pre-legislative style hearing brief, at the legislative style hearing, and in their post-legislative style brief, that unless the commission grants the dispositive motions that are pending and denies the application for a multi-year rate plan on the grounds that Pepco didn't meet its burden of proof, then it has to convene an evidentiary hearing to address the material issues of fact, because material issues of fact do exist. And the material issues that were identified.
You're now pivoting to your other issue, right?
Excuse me?
You're pivoting now to your broader due process issue, and you're pivoting away from you had to tell us what was in the record before before you issued your rulings.
It's a combination of those two issues. So we were at that time, this is in July of 2024, and the order on the application was November of 2024. We were identifying the issues that the commission would have to address at a hearing if it did not deny the applications. And those issues were the appropriate level of Pepco's rate base, which is essentially the plant on which the commission calculates a return that goes into the cost of service that is used to calculate rates. We identified the accuracy of Pepco's projections of its future costs. And that's of critical importance here because in a multi-year rate plan, unlike the commission's traditional approach, we're not basing rates on historical costs that have already been incurred. Pepco's projecting its expenses, it's projecting its capital investments, and we're basing rates on those projections. So we raised material questions of fact about the accuracy of those projections and Pepco's ability to even accurately make projections at all. We identified the deficiencies with the reconciliation process that was proposed to allow kind of an after the fact look at prudency. We identified prudency of the investments in the prior plan because that sets the starting point for the rate base that feeds into this case, as well as whether we have sufficient transparency and opportunity to be heard on that reconciliation process.
Can you just try to give me something more tangible? Just one thing. We would have called this witness or cross-examined this witness to establish this fact, which would have potentially altered the commission's decision. Can you give me your best shot at that?
Sure. So one specific example, AOBA challenged the calculation that Pepco used to create the billing stabilization adjustment rate, so the billing determinants. And AOBA argued that Pepco was inflating customer counts, which is that billing determinant figure, and therefore the deferral balance that Pepco was seeking to recover from customers was overstated. AOBA had its own.
Let's pause there because I want to get my head around that, and I don't have it. I'm not there yet. So Pepco is inflating is inflating what now?
The billing determinants, which are basically, I think at a high level, you could think of as the customer count. So we're looking at us taking a certain amount of revenue and
Like
dividing
really
it by
concrete.
a bot.
They're saying they're X number, they're saying they're 1 million customers when in fact they're only 500,000 customers.
That's
or
the nature of the dispute. AOBA is saying that their calculation is wrong because the estimate it overstates customers. And
Okay.
AOBA had its own calculation.
Right.
We identified that as a material issue of fact. It's a material issue of fact that AOBA has preserved for appeal and raised in its brief. That was one of many issues.
And are you saying
we
you
did-
could have brought in, or AOBA could have brought in a witness to say, this is the real customer account. There are only 500,000 people or 50,000 people in this category, not 1 million people.
So yes, that's one component of it. AOBA had its own independent witness who would have testified and been subjected to cross-examination himself as to the basis for his calculation. And then we would have had an opportunity to cross-examine Pepco's witness on the veracity of their customer count, the basis for why they have a different number, basically establish the record that the court should look to under the arbitrary and capricious standard
Does
to
this
make sure the
happen-
commission ties the analytical knot from the evidence to its findings of fact.
And does such cross-examination happen with regularity in other evidentiary proceedings before the Public Service Commission?
This commission has a trend of not convening evidentiary hearings. And this is the latest case in that trend where there was no evidentiary hearing at all. And we have a problem with that just as a threshold matter. We think there's a statutory right to an evidentiary hearing unless the commission provides detailed analysis as to why it can issue a ruling on the merits without an evidentiary hearing. And we don't think that analysis exists in the record. But more troubling, what the commission has done is it has essentially converted any issue of fact at all. And utility rate cases, as we just discussed, are very esoteric and they're fact intensive. But the commission has determined that what we deem issues of fact are actually issues of policy or law. And it's gone so far as to say that an issue of whether a cost is prudent, whether a cost is accurately calculated, the rate base, which is the starting point for all the plant investment that's been made that feeds into rates, all of those issues are policy issues.
And
And on that
presumably,
basis-
on those issues, those are issues that you'd like to put in expert witnesses to talk about, I imagine?
Those are issues that we have had what expert witnesses addressed in pre-filed testimony and that we would have addressed on cross-examination. And our witnesses would have been available for cross-examination to address at an evidentiary hearing. So that's the second component. The evidentiary record was incomplete because we didn't have any of that evidence that is normally elicited at an evidentiary hearing. And then the evidentiary record that did exist was deficient because we had no notice of what that evidence was. So no opportunity to object to the admission of any evidence. And if our objections were overruled, no opportunity to argue about the weight that should be afforded or should not.
Why
be
didn't you have
afforded.
an opportunity to object to the admission of evidence? You know, they've put forward their evidence. You have a chance to file pleadings. Why can't you say, don't consider all that stuff in your written pleadings?
We made preliminary arguments as to why we thought the commission should or should not consider certain materials, but there was no formal evidentiary record or exclusive record as
Okay.
section 509C
Let-
defines it.
Let me see if let me do my best to convey this point and ask the question. There are senses in which, you know, what rate base, how they calculate BSA really can be a policy question, right? I think one of the arguments that the OPC put forward is don't make, and I apologize, I can't get the acronym right, GTLV? Don't make the GTLV consumers bear the whole brunt of the shortage during the beginning of COVID. Spread that around. Spread that deficiency in Pepco's revenue to all consumers. That raises what I would think would be a truly policy level question. And they could say, well, no, we're not interested in doing that. That's not a factual dispute. That's just a question of how they want to set their policy. So that was one of your arguments where I thought, well, sure, you know, does not raise any issue of fact that I can see. And I'm not sure what percentage of the discrepancy in the expert calculations were between the 8 million and the 49 million. I'm not sure how much of that accounted for the 41 million delta. I'm sure I'm getting the numbers slightly wrong. But I'm not sure how much that accounted for the delta. Then there is something that you're now describing, which truly sounds like a factual dispute, that you just have different experts who are calculating the consumer, like how many consumers should count when we're talking about the costs, and then how do you calculate projected revenue based on that same consumer base. That sounds like a truly factual issue, and I think I hear you saying, you know, this was a battle of experts. We deserved to cross-examine theirs. They deserved to cross-examine ours. Then the commission could make some factual assessment of who came across as more reliable. And doing that on paper, while, you know, you can assess credibility somewhat on paper, is not the process that the statute contemplates. Do I have that right?
For the most part, I
Okay.
would first clarify, AOBA never.
I'm shocked that I got for the most part.
And that's not doing it enough justice. It was very close. I would clarify, AOBA never argued that deferral should be spread to the other classes. AOBA simply argued that PEPCO did not provide a sufficient evidentiary basis, and the commission did not provide a sufficient evidentiary basis for allocating it to the GTLV class. As to the factual differences or the facts in dispute, AOBA had its own calculation and PEPCO had a calculation. So there were competing calculations, and which is a factual matter, not only.
This was the revenue shortage from this class of consumers that took place from, I don't know, 2021 to 2023, roughly, something like that?
Yeah, the issues are very closely related, but yeah, that's exactly it.
Okay.
But then the third point that I want to make, and this is critical, the commission contends that it can make calls as to witness credibility, or it can decide issues of dispute among witnesses based on the written record itself. And I don't think that's accurate, because under cross-examination, that's where you really get to determine whether a witness, when scrutinized on the witness stand, can support its testimony or not. But the problem here is we have 101 responses to data requests that the commission ultimately admitted into the evidentiary record that are not sponsored by any witness whatsoever. And these are record items 74 and 75. There's a confidential version in public, and 364 and 365, the same thing. So 101 responses to data requests that are not sponsored by any witness whatsoever. They're sponsored generically by the company. So even if we were to look at this issue in a light that's most favorable to the commission and say you can make calls of witness credibility based on the written submissions, it's impossible to do that when there is no witness. And we would have had an opportunity at the evidentiary hearing to ask witnesses whether they could support the information in those 101 responses. If not, that's a serious problem, and we never had that opportunity.
Are you hanging your hat on 2509? Are you, so I take the statutory requirement to be something like, here's how I read it, and you tell me if I have it wrong. To the extent necessary, if you really need it to get to the facts, you have a right to bring in live witnesses and cross-examine them. But otherwise, submitting this and making decisions on the record, on documents, that can be fine too. And your argument is, well, just on these facts, this record is so contested, and we frankly, like the dissenting commissioner said, it's really tough to tell what the commission was, why it credited PEPCO's calculation of the BSA deferral revenue. Ugh, I'm sure I'm getting words wrong, but
That's correct.
I'm in the area. Why they credited PEPCO's calculation versus AOBA's, we have no idea. And in order to do that at all, you would have had to subject these witnesses to some cross-examination, because otherwise it's just too complicated, too dense, they're too far apart. How do you fill out that sentence?
It's both of the fundamental errors that I noted at the outset. It is complicated and dense, and therefore cross-examination is incredibly helpful to not only get further elucidation of the issues, but also to determine that the witnesses have the ability to testify as to the issues that they put down on paper. So did they have help with their pre-filed testimony and analysis? Can they actually support it? But then also, we would have had an opportunity to submit cross-examination exhibits that go to credibility, that could possibly undermine the witnesses, the basis for their testimony, could support the basis for our testimony. So there's a problem with the information that the commission considered solely on a paper basis, and then the information that was never considered because there was no hearing. But two other points I'd like to make in response to your question. One is, I think you're precisely right in identifying the dissenting opinion, and this is a fundamental problem we have with the orders. The commission does a lot of explaining about what it did, but the orders are very light. If not, there's no discussion as to why the commission did what it did. So if you look at paragraph 562 of the first order, 22328, that's a section called Findings of Fact and Conclusions of Law.
Sorry, where are you pointing us?
Paragraph 562.
562, got it.
Yes.
Right.
The commission combines what it calls findings of fact and conclusions of law. There's 29 separate paragraphs under that heading. It's very difficult to find any of those that I would characterize as a actual finding of fact. A lot of them are just statements of law, but there's nothing at all that explains why the commission did not adopt AOBA's testimony. There's nothing at all to suggest that the commission ever engaged in an analysis of witness credibility, pitting one witness against another. And there's nothing in the orders that show that either. Again, what the commission has done is explain what it did, and it has not explained or provided any analytical framework this court can track to see why the commission did what it did and why what it did is reasonable and why what it decided not to do. So why did it not elect an alternative proposal? Why that decision is reasonable? We just have conclusions, and that's not sufficient under the arbitrary and capricious standard. And that's one of our principal concerns with the challenged orders.
And just to clarify sort of what the legal foundation for your process argument is, I mean, the briefs say a lot about due process, but there's not a lot of law in the briefs about, I mean, I think there's one citation and a footnote to Matthews versus Eldridge in your initial brief. I don't think AOBA's brief cites any cases on due process. So, I mean, we usually like people to actually brief their constitutional claims, and this doesn't, I mean, so I take it that you're really hanging your hat under the APA and saying, look, this is a contested case. We're entitled to contested case procedures. That's a yes. Does the Public Service Commission have regulations about when it's supposed to have evidentiary hearings? I mean, you indicated that they have sort of fallen out of favor of late, which I'm curious to hear if you have a reason for that change of heart, if that's in fact the case. I have no sense of it, but you know, do they have regulations that require them to have evidentiary hearings at any point in time?
Yes, so taking the first part of your question before getting to the commission's regulations, our principal argument is simple. It's a statutory argument. There's a right to an evidentiary hearing for a true and full disclosure of the facts. We did not have that. Therefore, we didn't have a chance to create that body of evidence that would have gone into the record. We also made constitutional due process claims, and
I know you assert them,
well,
but they are really not argued. I mean, there are no cases cited in the briefs that support, you know, and I think actually in the reply, the PSC responds to the Matthews versus Eldridge citation and says, you know, that this is satisfied. And the reply says, we're not talking about Matthews versus Eldridge, and then doesn't cite any other case supporting a due process theory to explain why this process on these facts that we've discussed at some length at this point, why due process guarantees were not satisfied. So I think, you know, I mean, we have case law that said,
Certainly,
you know,
we
it's
could have
not
been
our
more-
job to figure out why there's a due process violation.
Certainly.
But, you know.
We could have been more precise, but really, like I said, it's a simple statutory argument, and the due process considerations that are discussed in Matthews v. Eldridge really overlap with and are no different than the due process considerations under the APA, or the APA, excuse me. Did we have meaningful notice and a meaningful opportunity to be heard? And we did not. And then as a matter of legal error on appeal, we have argued that the commission has an obligation to respond meaningfully to our arguments. It did not. That's a legal error. By not providing notice of what the evidentiary record was until the commission issued its order ruling on that evidence, we were denied an opportunity to respond meaningfully to what that evidence was because we didn't know what it was. So again, we could have been more precise, but really it is a simple statutory error that overlaps with all fundamental due process rights to notice, adequate notice, a meaningful opportunity to be heard, and then imposing upon the commission the obligation to respond meaningfully. But getting to your question on regulations, I don't think that the commission has regulations as to whether it can have a hearing or not. And I think that's because it's set in statute that there is a right to a hearing where one is necessary.
I mean, oftentimes these things overlap, right? That there's a statute that says you're, you know, supposed to have contested case procedures, and then the, whatever agency sort of spells out when and how they do it.
Yeah.
But
So there's
you're
no,
saying there's nothing in that.
there's no regulation that I'm aware of. Really, it's a policy that's been articulated in a series of orders where the commission has explained its view on what is not a material issue of fact, and it defines those issues primarily as issues of law and policy. And again, all of those issues that the commission defines as issues of law or policy are the fact-intensive nuts and bolts that make up the cost of service that goes into rates. So the accuracy, and this is in paragraphs 30 and 32 of the second order, 22358. The commission says the accuracy of cost projections, issue of policy, rate base, issue of policy, prudency of an investment. So comparing what a prudent management would have done versus what, what investment decisions prudent management would have taken versus the management decisions that Pepco taken, issue of policy. These are not issues of policy because no issues before the commission, and getting to Judge Dial's question, are really that simple of pure factual issues or pure policy issues or pure legal issues. They are mixed questions of law and fact and policy. And the commission cannot make policy judgments in the abstract. It has to have a factual underpinning for implementing the policy to demonstrate that implementing the policy underneath the facts and circumstances of this case is appropriate. And let me just give you one specific example. In the alternative form of regulation framework that the commission adopted in the prior rate case, which set out the standard it will apply in evaluating future proposals for alternative forms of regulation, the commission says that it will determine whether the mover, whether the proponent of that proposal has demonstrated the propriety of an alternative form of regulation under the facts specific to that case. Now, as a policy matter, whether to have an alternative form of regulation, there's clearly a strong policy element there, but there has to be a factual basis for it, and the commission itself acknowledged that. And here we don't have any discussion of those facts because the commission, in a very overly simplistic way, identifies essentially every issue as an issue of law or policy. And that's a problem here in this case, but it's a problem looking ahead because it's hard to imagine if the court affirms the commission's reading of what's a legal or policy issue, it's hard to imagine that any hearing would ever be required in any case, because this case was one of the most complicated in terms of fact-intensive issues, given that we're looking at projections and not just historical costs, given that we have a historical test period, an alternative proposal, we have a lessons learned exercise on top of that. This was a particularly complicated case. So if no evidentiary hearing is warranted here under these facts, no evidentiary hearing would be warranted ever under any fact.
Think there's ever a pure policy question?
I think there are pure policy questions, but whether they allow for resolution of an entire rate case without a hearing, I cannot imagine a circumstance like that. I think most likely there's mixed questions of law, policy, and fact that require a factual basis. I think the commission cites the Watergate case to support its decision. That was an issue, or that was a good example of where there was a pure legal issue. So not what we had here. That was one discrete issue, which was the effect of a subsequent rate filing on a pre-existing rate. How did that subsequent filing affect the pre-existing rate, if at all? That was a single issue. It was a very discrete issue. Commission found that was a legal issue. No hearing was required. And the commission relies on that case to say, we don't have to have hearings where there's legal issues. Well, that's a statement of the standard, but the commission does not apply that standard here. And I think the reason it doesn't is because it's not possible to say there's not a single material issue of fact in this case. And not only does the commission say there's not a single issue of material fact, they accuse OPC and AOBA of failing to identify any. They say we did not identify any issues of material fact. In the reconsideration order, they say we identified, I believe, 3. Rate base, which they deny is an issue of fact. They say it's an issue of policy, and then an issue with respect to a similar proposal in Maryland. But again, we identified the accuracy of the forecast, the level of the rate base, the calculations that Pepco performed. Return on equity is always a major issue of fact. Now, it has economic components, it has policy components, but there are factual underpinnings that must be determined. And we identified these issues of fact all throughout the case. In the dispositive motions, we argued if the commission does not deny the application for a multi-year rate plan on the grounds that Pepco didn't meet its burden, then there are material issues of fact that must be addressed at hearing. In other words, the commission can deny it on burden of proof grounds, but it can't approve it based on the pre-filed submissions that exist at that time. A further record must be developed. And prior to the July 30th meeting that the commission referred to as a legislative style hearing, the commission noted that it was not granting those dispositive motions because a more fulsome evidentiary record needed to be developed on these issues of first impression. But no evidentiary record was developed beyond that point. The commission simply admitted the responses to data requests, many of which, like I mentioned, were not sponsored, and then the pre-filed testimony and exhibits. There was no cross-examination. There were no exhibits submitted on cross-examination like hearing exhibits or impeachment exhibits.
Counsel, I mean, maybe this is a question for the commission, but I'm sort of curious why, after saying, look, we're not giving you summary relief because we think the record needs to be developed more, did the commission then say in the order 22-013 that, look, we're going to have this legislative hearing and we'll tell you, I think it's in that order, we'll tell you if an evidentiary hearing is necessary after the legislative hearing, which seems backwards if a legislative hearing is an oral argument. But I mean, I just don't understand the process here.
We don't either. At the evidentiary hearing, or at the legislative style hearing, the commission made clear on at least 3 occasions that we have not yet decided whether to hold an evidentiary hearing. If we do, we will let you know. And at the evidentiary or at the legislative style hearing, both counsel for AOBA and OPC again reiterated, if you do not grant the dispositive motions and deny the multi-year rate plan application on the grounds that Pepco failed to meet its burden of proof, then you must establish evidentiary hearing procedures because the record as it currently exists, the pre-filed materials, does not support a reasoned decision on the facts. There's simply not enough record developed to make that decision. And that's what the commission did 4 months later, was issued a decision without further developing the record.
Thanks, Mr. Gray. We'll give you a couple minutes on rebuttal. Okay.
Can I address briefly the AOBA specific issues?
Very briefly?
Okay. So AOBA has raised 2 specific issues. One, actually, I think both we touched upon briefly. They are the billing stabilization adjustment deferral balances that the commission has imposed upon customers in the GTLV class. And the other one is the effective rate adjustment issue. So I'll start with the effective rate adjustment issue first. At a very high level, the effective rate adjustment in Pepco's, according to Pepco, is necessary because there's a mismatch in those billing determinants that we talked about over time. So rates are developed based on billing determinants as they exist in time. And then as customer counts change, the amount of revenue that Pepco actually collects is different because it's being collected from a different pot of customers, a different number of billing determinants. Pepco calculated that effective rate adjustment at just over $30 million. And so what AOBA argued was, you've already found a cost of service, a total cost of service increase at $123.4 million for the entire system. And you've allocated to AOBA its portion of that, an amount that you found to be appropriate to allocate to AOBA. But on top of that, you're now adjusting the billing determinants because of a purported shortfall that these billing in revenue that these billing determinants would produce as compared to forecasted revenues in the future. We argued there's no basis for an adjustment to collect a shortfall to forecasted revenues. And then on top of that, AOBA argued the commission has a policy called gradualism, and gradualism essentially is the commission's attempt to avoid rate shock by subjecting customer classes to a substantial increase at one time. It will ease into that rate increase to mitigate the effect of rate shock. AOBA argued that the effect of the BSA adjustment and the effective rate adjustment increases the costs allocated to the GTLV class by over 60% from what the otherwise applicable rate increase would be, the amount that was allocated to the GTLV class from the total. And we argued that nowhere does the commission address, much less even acknowledge, its gradualism policy or demonstrate how this level of a rate increase is either consistent with that policy or explain why it's not applying that policy. The challenged orders say nothing about gradualism, and the commission says nothing about gradualism on brief to this court. With respect to the billing stabilization adjustment, I'll just make one additional point. So we have the issue that we talked about where the commission explained that it was adopting PEPCO's calculation, didn't explain why, and it certainly didn't explain why it was not adopting AOBA's. The only other point I would raise is that the commission accuses AOBA of ignoring these other findings that the commission made on the billing stabilization adjustment. And in particular, that the commission was establishing a working group to consider whether a change to what's called a demand component, so basically just a change in how that rate's constructed, would address AOBA's concerns. That rationale or that argument does not address the concerns because we have a problem now. So even if we can assume that a future working group will come up with a solution that actually solves this problem, that doesn't do anything about the harm that these orders impose on AOBA. And we cannot speculate that that future work will actually come up with a solution that will work. So we're looking at that issue in the light most favorable to the commission, saying if it's even possible that a solution will be determined in the future, and we don't think it is, but if it is, prospective relief is not sufficient to address the substantial rate impact and the unsupported rate impact that are the result of these challenged orders. And the commission had no response to that argument as well.
So there's no, and question is premised on my really incomplete understanding. There's no world in which some overpayment could then be credited back. If the working group looked at this and said they vastly overpaid, this group of consumers, that it could be credited back. I mean, my again, very basic and possibly wrong understanding of now I can't even remember what the acronym stands for, the BSA, the Billing Stabilization Assessment, right? Is that it can go up or down, right? So could it go down and send money back to people who overpaid or no?
The way the billing stabilization adjustment works is there are fluctuations over time, but the only world that exists where the current overcharges would be corrected is the one we're in now, where we're asking the court to vacate the orders because the impact of these orders is not supported. There's no future opportunity to make today's ratepayers whole from any work that the working group performs.
And did I hear you correctly say that the bill stabilization adjustment is only for actual costs, either too much or too little? It's not for future projected costs. Is that?
We
what you
argued that
said?
there was no support, no precedent, no policy, no support for PEPCO's proposal to apply an adjustment to future forecasts of revenues. And the commission again simply says that's what we're doing. This mismatch exists because the changes in billing determinants. So that's what we're doing, but no support was offered. And again, there's a nuance here. The mismatch certainly exists, but that's not the end of the conversation. The end of the conversation is why does that mismatch exist? And the commission found that PEPCO's inability to forecast accurately contributed to the size of that mismatch. So contributed to the size of the rate increase that was being imposed on the GTLV class, but did nothing about it, and found that the rates being subjected on the GTLV customers were reasonable without any independent quantification that would support that finding, that would support a finding that a $23 million rate increase plus a $30 million adjustment plus the deferral balances would be just and reasonable. Thank you.
Thank you very much. And again, we will give you a couple of minutes on rebuttal.
Good morning, Your Honors. I'd like to allocate 5 minutes of my time to PEPCO. Good morning, Your Honors. May it please the court, my name is Brian Edmonds, appearing on behalf of the Public Service Commission, the respondent in this case. The commission asked this court to affirm its decisions because they rest on a complete record before the commission, comply with due process requirements, and reflect a reasoned, evidence-based decision made by the commission. The commission's decision to hold a legislative hearing did not deprive the petitioners of due process and was consistent with this court's holding in Watergate East and other decisions by this court. And so the commission's argument is that the commission not only gave sufficient due process, but actually exceeded due process for the petitioners in this case.
Counsel, do you agree with this description that a legislative hearing or a legislative style hearing is really just oral argument by lawyers? Is that an accurate description of what?
That might be what some may have deemed
Does
legislative.
it have
hearing to be.
another purpose?
But no, actually, this is actually an extension of the commission's legislative function in rate making. And it enables the commission to come in, as it did in this case. The order 22013 lays out exactly what was going to take place, Your Honor. To the extent the parties, even though the commission had denied the motions for summary judgment, to the extent the parties had any issues that they wanted to raise, even address issues of fact that they believe were in dispute that required a hearing, they were perfectly well to do so. At this particular hearing, the lawyers gave presentations. The commissioners had questions about some things that they were thinking about that were relative to their decision in the case, and that was perfectly appropriate to exercise the commission's legislative function at that hearing.
It just seems odd to say, well, we're going to have this hearing that's essentially sort of the argument by lawyers that one might have after you've figured out what the relevant factual universe is, and then say, we'll have an evidentiary hearing after that if we need to, which is what I understood that the commission said in that order, the 22013 order.
It left open the possibility that it would.
Is that something that happens often, that it does it that way?
Well, we've held one legislative hearing in a rate case before, other than this one. So, and there were no issues of fact that were identified as in dispute, and the commission made the determination that we would go forward with a legislative hearing. In this case, the motions were filed indicating that there were no issues of fact. 2 motions were filed. And so at that point, there was nothing on the Watergate East for the commission to hold an evidentiary
Well, the
hearing.
commission determined, because it sounds like the OPC and AOBA were saying, no, we've got issues of fact that we would like to flesh out at an evidentiary hearing, but the commission decided that no,
I'm
nothing.
not sure at what point they raised those issues, Your Honor. I think, we relied on their representations in their 2 motions, that there were no issues.
No, I mean, they were saying if you rule for us, there are no issues of fact. If you see the evidence our way, but if you disagree that we're entitled to summary relief, then we need an evidentiary hearing. Those aren't inconsistent. That happens all the time.
True, but the commission didn't specifically deny the motions because there were or were not issues of fact. It was on the second prong with regard to whether or not the litigants were entitled to relief as a matter of law. And the commission was not sure from the policy and legal issues that it was appropriate to grant the summary judgment at that point because there were some open questions.
What about some of these factual issues that OPC has raised, saying like, look, there are disagreements on something as basic as sort of what's the customer base here, and they're saying it's this number, PEPCO's saying it's this number, and we're saying it's this much lower number, and we need to hash it out. We need witnesses to come in, testify, and we can cross-examine, and they can cross-examine, and the commission can hear, and the commission can make a factual finding about what the customer base is. Is there a factual finding in the initial order as to what the size of the customer base is?
No, there is not.
Okay.
But the commission did address the concerns that are raised. I don't think there was any dispute among any of the parties with regard to a problem with the customer count by the company rather. But it's important to recognize that the commission acknowledged that.
You don't think that issue was raised, even though that's what counsel gave as an example as one of the disputed issues of fact?
I don't recall that being isolated among the parties. It may have been something that their witnesses testified to, but the commission recognized there was no.
I'm sorry, their witnesses when were?
In their pre-filed testimony. So it's pre-filed testimony that the commission is looking
Okay.
at
Those
from
are
all the parties.
Okay.
And so that's before the commission. The commission is making this determination based on that. It may not need to have cross-examination of witnesses on facts that are not in dispute. And I think that's where we're having difficulty because the petitioners may be coming before the commission because they dispute or they oppose or they contest a particular rate
Right.
application, but it doesn't raise to the level of a contested case that will require an evidentiary hearing unless there are issues of fact that are in dispute that need to be
Sure,
resolved.
I just understood OPC's counsel to say that there was a particular factual dispute about the customer count. So I'm sure he'll get up on rebuttal and tell me where that was raised, in which case it seems very odd that the commission just didn't resolve it. If,
Well, I think the commission did resolve it. I don't think
I
there was
thought
a.
you said that they didn't
Well,
resolve it.
with regard to the number, but I think what the commission did is recognize that there was a problem with the customer account. There were billing determinant problems. Everyone is clear about that. What the commission did in response to that is penalize the company $50.3 million for those errors, as it was looking at how
How
it
did
was.
they know that there were errors if they didn't make a finding of fact?
This is something that the parties all attested to. I mean, that's what the commission.
So you're saying Pepco agreed that there were errors? And so they didn't
And the-
need, but
and the-
did they agree on the magnitude of the error?
It's my understanding that this was discussed in a working group and the dollar figure, $15.3 million was identified. And I don't recall there
But the
being,
working group is happening separate from this.
I understand, but I'm just trying to fill you in with regard to how this came before the commission. And this is, recorded in order 22328. But there was an identification of a $15.3 million associated with the error in the billing determinants. And that was understood to be the amount of the error, and the commission accepted that and penalized the company for that amount.
About this statement in the reconsideration order where the commission says that we don't need cross-examination to assess credibility or to make findings. We can just decide which witnesses to credit based on written testimony and exhibits. That just seems wrong procedurally.
Well, I mean, if
Because you were saying there aren't any material issues of fact. But then the commission says in this order, well, even if there are, we don't need to have confrontation of witnesses.
I'm not sure I would agree that that's what the commission said with regard to the need for confronting witnesses. The commission's determination as to not having an evidentiary hearing in this case was driven by the petitioners saying that there weren't any issues of fact. When they were asked at the legislative hearing, counsel for AOVA and counsel for OPC with regard to what their issues were, they just named terms like prudency and rate base and things of that nature. Those may be issues, but we're not sure what the dispute is with regard to those issues and what facts underline the dispute. That's what the commission is aiming for in trying to make a determination as to whether or not there needs to be a hearing, there needs to be cross-examination. I think that's the fundamental difference.
I mean,
between-
this is the passage that just flummoxed me. If a dispute about whether a matter is true or false and it's material to the commission's decision, it may rise to a genuine issue of material fact in dispute, and an evidentiary hearing may be required. However, there's little need for a formal hearing so each party can cross-examine a witness on their opinion or to allow parties to determine whether a material fact exists. The commission can decide which witness opinion to credit based on written testimony and exhibits. I don't know what that means. I mean, it just sounds like, well,
It's at least not what we're used to.
So,
what were you?
so if I can help you, there have been cases for, I've been doing this for 25 years. And I would agree that up until the last 7 to 8 years, the commission has had evidentiary hearings. And it may, excuse me, may be that a witness may be asked some questions about something, but it may not necessarily be contested as far as a dispute that may exist between the parties, and allow the witness to testify. What the commission has found leading up to the decision in 2017 to go to the streamlining of cases is that none of the testimony was really of any probable value for the commission in making this.
That's not what that paragraph.
I understand.
said.
I'm getting to the point.
Okay.
And so what this basically is saying is that we're receiving direct testimony, supplemental direct testimony from the parties, rebuttal testimony, rebuttal testimony, and we have all of this information before us, all of the data request responses before us, and our technical experts are going to review the information And if we have questions, the commission will ask questions through data requests from the commission staff. So it's not like we're just receiving things in.
Does it sound like what the APA requires in a contested case proceeding?
Well, that may
I mean,
be,
that maybe works for the commission. And I'm curious, so this is a new policy as of 2017. Is this policy written down anywhere?
This-
Are
this
there
is not a-
regulations?
this is not a policy. This is a practice the commission is
Okay, it's a new
undertaking,
practice as of
Right.
2017.
but
But
to res-
is it documented anywhere?
just in the orders that the commission has issued, there's a number of orders where the
So
commission has
in
issued.
each case, the commission is documenting that they're following this new practice
That is correct. We're
of not
streamlining
having
our
evidence,
cases.
streamlining.
Right, but if I can speak to one thing with regard to contested case, the commission's position why it decided to go with a legislative hearing is that it doesn't believe under the definition of a contested case in section 2-502 subsection 8 that this is actually a contested case. When you look at the definition of that, and this court has actually opined with regard to whether or not rate making is a contested case matter. And this court has said that its definition of contested case does not refer to rate making, and the legislative history of the DC APA, Congress does not recognize that rate making is adjudicative in nature. So there's a question with
Mean that this case shouldn't be here? Right? If it's not a contested case proceeding, we don't have jurisdiction. Right? And whether it's a contested case proceeding doesn't turn on whether there was actually cross-examination in any given case. It turns on whether they're entitled to it, right? Either under the statute or under the Constitution.
Right.
So are you saying that the Court of Appeals should be divested of all jurisdiction over Public Service Commission rate
I'll leave that to
setting?
you to decide. I want to go to the
I'm
next
so
thing.
sorry,
Back
but
to
I'm
that.
gonna ask you to answer the question because that's why we're
No.
here, right? Like, I don't just opine on things that have not been raised to me. You are making the point now that that we have somehow indicated in a case, I'm sorry, I missed the name of the case that you said that
Oh,
we,
CWA versus Taxi Cab Commission.
do you have a site for that?
542 Atlantic 2nd, 1121.
What year?
$1988.
Gosh, that's a long time for us to be deciding these cases without jurisdiction if they're not contested cases. I mean, I'm
Commission's position is,
surprised
right.
by this argument that you are not quite making.
Well, we believe that the Congress was initially, before the commission was established in 1913, Congress set rates.
So do you think
So-
in a decision in this case that we need to address to either affirm our jurisdiction or, I mean, do we need to get supplemental briefing on whether or not we actually have jurisdiction to decide this case?
We certainly would welcome it, but we think it is important for the court to opine and give us guidance going
I
forward.
mean, you didn't brief this issue.
Understand?
Yeah,
I understand.
okay.
But
Can I ask, just on a concrete point, I suppose I would be more sympathetic to the view that maybe the discrepancies between witnesses could be resolved on the papers if I understood how those discrepancies were in fact resolved from the commission's order. And so I just want to, I'll flag sort of the concluding paragraph of Commissioner Beverly's dissenting opinion in 22358, where he says, look, we have, in terms of how you calculate the BSA deferral balance, we've got AOBA up here with an $8 million, that's what they say the deferral balance would be under their calculations. We've got PEPCO saying it's 57 million, that's a $49 million discrepancy. The commission credits PEPCO's calculation without any explanation. He's just gonna, 'cause I'm at a loss for understanding why they credit PEPCO instead of AOBA, and as am I. So, I mean, you could view that one of two ways. One way of viewing it is, well, maybe there just is an adequate explanation, and that's the type of thing we might remand on to explain it again. But you could also view it as it seems even based on how the commission just kind of went whistling by that graveyard, that they don't have anything to say about it because they haven't heard from the witnesses. It's the type of thing that it does seem like cross-examination would probably illuminate. You know, which of these experts actually sounds like they know what they're talking about is kind of a classic credibility determination that we expect fact finders to make. And the commission's silence on that, I find a little bit troubling. Do you think, am I right? Is the commission silent? Do they give an explanation, do you think, for why they credit Pepco's 57 million versus the 8 million offered by AOBA?
Beyond just crediting the testimony, I think that's all that we have here.
Okay, and why isn't that something that an evidentiary hearing seems necessary to figure out which of these experts? I mean, if they had said, you know, this guy is, his numbers don't even add up. He doesn't know what he's talking about. He's doing basic mathematical errors. That I would get. He's basing this on some policy judgment that we reject. That I would get. I just don't know what the basis is. So I don't know how I could uphold a holding like that without some explanation. Okay.
I mean, I understand your point. The commission weighed the evidence based on the testimony of the various witnesses and credited the Pepco witness in this regard. That's certainly a policy decision that the commission made in that regard. Not only did the commission rely on the explicit assertions made by the petitioners that there were no material issues of fact, the commission actually also responded to the concerns that were raised by AOBA, and on behalf of the GTLV class, the commission corrected certain things with regard to the ERA and the BSA with regard to, I indicated earlier, the deferral balance of $39.7 million. There was universal agreement that that needed to be moved to a regulatory asset. AOBA didn't oppose that. With regard to the penalty against Pepco, there were some additional adjustments to the ERA and the BSA that the commission undertook. And I think it's important to recognize that the commission didn't just blindly approve this without considering some of the problems that were inherent that everyone knew about that existed with regard to the ERA. Reconvening the working group to see if there were additional modifications and reforms that needed to be made, and also had the company to conduct an audit with regard to its forecast. Everyone was concerned about the forecast, and so the commission thought that was just something that needed to be reviewed carefully. With regard to the BSA, there were some modifications, again, reflecting the commission's understanding of some of the challenges that the parties experienced with regard to the BSA. The deferral balance, as I stated earlier, annual surcharge, moving from a monthly to an annual surcharge for the BSA to sort of smooth things out for the parties, a separate line item in the BSA on bills so people would know exactly how much the surcharge or credit was going to be for that particular month. And actually an additional annual true up to sort of prevent this problem occurring in the future with regard to the massive deferral bill increasing. So the commission took appropriate actions under the record to ameliorate some of the problems and concerns that were raised with regard to the BSA and the ERA.
Can I ask, as a practical level, at a practical level, sort of how the timing of this case, you know, how concerned should I be with it? Where, you know, we're talking about a rate setting for 2024 to 2026. You know, 2026 is just around the corner. This is a fairly complicated case. Let's just say it takes us, you know, 6 months to decide it. We're then almost halfway through 2026. I don't really have a sense of what the remedy would be if, you know, is the commission, if we said, look, we think there are some factual disputes that there should have been a hearing on. Is the commission then holding hearings in 2026 about what rates were already set for purposes of clawing back some revenues? I just have no idea. It seems, I mean, this kind of sounds, I doubt it's moot. I assume there is some remedy. I just don't know what it is. I don't know if it behooves us to rule tomorrow, to put our foot on the gas, or maybe to put our foot on the brake and wait until 2026 passes and make it all go away. What are the practical implications of the timing of this case?
Well, it obviously depends on what the court believes is necessary that the commission needs to review on remand. But I think we have to be careful about the fact that you don't want to disturb settled expectations. These rates have been in effect now for almost 11 months.
Hypothetically, totally hypothetically,
Sure.
say we thought the commission's ruling, the commission should not have ruled without having an evidentiary hearing. Say we thought that was just absolutely clear. And
Right.
I'm not saying that's our position right now, but say that were the case. Then what would happen?
We would probably start with asking the parties to identify which issues of fact.
Say they identified the issues, say the hearing was held.
Right.
Say a different result was achieved, then what happens?
I think it depends on what that result is. as far
Say,
as the impact
say
on
it
rates.
meant that AOBA had to pay less.
I'm not sure. I think that is potentially a concern with regard to rate making that's retroactive. And so I would be concerned about that. I think we'd have to do a little bit of a holistic, because that would then necessitate that other rate classes would absorb whatever the shift is in the credit to AOBA. And I think that's a little bit more complicated for the commission and the parties to identify in a hearing and to address.
I mean, there has to be a way to, in my hypothetical,
Mhm.
for an entity that has been overcharged as a result of a process that was incomplete, to be made whole, no? Or you?
No, I agree with you.
Okay,
I just think that it's
it'd be
it's
complicated.
very complicated, yeah.
Yeah.
And so I don't want to say it's a slam dunk that we can do it and fix it real quick. I think it's a little bit more challenging than that.
To Judge Deal's question, is speed from this court helpful?
Say yes. Because we do have another case that the company would be poised to file in 2 years. We're already, towards the end of this year. And so I think he's correct that, next year is the year that we have to get everything done.
Yeah.
If the company wants to come in to file for an additional increase. Yes.
Thank you.
So, Your Honor, the commission would ask that these orders be affirmed again. They rest on the complete record, comply with due process, and reflect a reasoned, evidence-based decision-making. Thank you.
Thank you. Counsel for Pepco, we will give you your 5 minutes.
Yeah, I will do my best. Good morning, Dennis Chamino on behalf of Potomac Electric Power Company. I bring up 3 issues. I'll try to get through them as quickly as I can. I think I can group 2 of them though, the evidentiary hearing issue and the issue that you just brought up. So, generally speaking, based on the pleadings and the briefings to the court, there does seem to be general agreement that there is a statutory requirement for hearings, but there also is an exception, and that's the Watergate East case. I heard it come up in the OPC argument before. We take some exception to how it was explained because while we agree it's a separate kind of case, it's not a Pepco base rate case, the court didn't limit itself in those instances to just the facts on the case. In fact, it cited an administrative law treatise in doing so. To us then, with those 2 general agreements, this really boils down to the applicability of Watergate East. As we explained before, we do believe, Pepco believes that the commission adequately explained its rationale. And I'd like to express a few points in support of that. First, to the specific point, the commission's decision, understood and interpreted at the appropriate level, approves an extension of the pilot initially approved by the commission in the previous case, 1156. Because the current case, 1176, is really just the same as the last case in terms of it being an MYP. And because that is a policy choice and within the commission's discretion, the commission's decision not to convene hearings is appropriate. I think there's more support if you look at Order 22328 itself. As both OPC and the commission point out, we're moving to a different type of case. Previously, we looked at the historic, and now we're looking forward into the future. In the order,
I just want to interrupt because
Sure.
I get that utilizing a multi-year plan is a policy decision rather than using a backward-looking rate plan. Okay, I get that.
Mhm.
But a lot of the complaints are about how the projections, like how the numbers are actually being projected. And that's not a policy question. That's sort of a math question. It's a factual question about sort of how many consumers are there? What do we expect their usage to be? And it seems to me that that's the type of stuff that they want an evidentiary hearing on, not the policy question but the factual question. So what do you think I'm getting wrong? Or do you think that's all lumped into a policy question?
No, but I do think you need to take apart each of those arguments. And so I plan on, if I have time, I'd like to get to the customer count issue that was brought up earlier, because I actually think it's not really the kind of issue that you would have at a hearing. But I'd like to get to that and please remind me if I don't.
Why
But-
don't you talk about it right now?
Okay, yeah, so I will jump into that. So that actually has more to do, I think, with the bill stabilization adjustment. I'm going to try to explain it at a 50,000 foot level. But essentially what we're doing here with the BSA, the bill stabilization adjustment, is based on a previous rate case, and ours was the previous one, 1156. There's a target revenue, an expected revenue that per customer that the company expects to receive. But each month, that level, as OPC counsel was mentioning, can go up or down. What essentially had happened over the years, and especially through the COVID years, is because that was based on a forecast, and that forecast was from 2018, that forecast gets less reliable. And then COVID hits, of course. So what you have is these deferral amounts, the amounts that were owed, and we showed in monthly filings, growing larger and larger and larger. So the customer count issue that you're talking about is always going to be a forecast. There's not going to be an exact number. The only exact number is what we actually could show in the appropriate filing we make with the commission each month. But each rate case, it's always going to be a projection. So the factual issue, it's really just an expert says, we think the forecast should be this, and well, we think it should be this. But that, to me, that's going to be the result is going to actually be borne out in the BSA filings that we make when we show what those, the monthly amounts is, the plus.
It's interesting because, I mean, I'm just so used to, and so maybe I just need to get my head out of this space. We see a lot of trials where it's my witness says this, their witness says that. That goes to a jury, that makes its way past summary judgment every time if you've got competing witnesses on the critical issues. And we say, well, it's up to the jury to kind of hear those experts and figure out which one they want to credit. To do that on the papers is at least somewhat foreign to me. But why do you think the commission can do that on the papers when it does seem like it's the type of thing that cross-examination would ordinarily illuminate?
So I don't disagree with you, and that has been my experience as well. So
Okay.
I've been doing this for about 15 years. That's about 6 or 7 rate cases. Prior to the last case, 1156, the one I was discussing earlier, that was the practice. They were lengthy and detailed, not always altogether useful, but it was a lengthy process. What the commission has identified is that there seems to be a practice that they've developed to streamline things. 2 of the last 4 cases did not have evidentiary hearings. So there was a Washington Gas case, that was formal case 1169.
Right, but here
Yes,
it is being raised as an issue, right? The
understood.
fact that it happened in a couple of cases
Yep.
where it wasn't raised as an issue is kind of neither here nor there. But now we're being told there's a new practice. We're essentially not having evidentiary hearings if we can avoid them, right? And the question seems to be kind of teed up in the background of this case. Is that consistent with the statute, which says if it's a contested case, you get contested case procedures, and maybe it's not super efficient. Goodness knows, if you go over to Superior Court and watch some of the trials over there, it's not the epitome of efficiency, but it's how we do it, right?
Yep.
It is the process that is used and is guaranteed and is, in the rules. And so here we have a process, we have the contested case process that is in the statute. And I'm not sure that the commission gets to just decide not to use the process that's in the statute, but that seems to be an issue that's lurking in this case.
Yeah, Judge Easley, I'm not arguing with the law. We do agree that that is the general rule. As I mentioned, we also believe that the Watergate East exception applies here. I think all parties do in
It's
the
not an
briefing.
exception. If I
is,
understand it, the
and it's-
Watergate East principle is if nobody's actually fighting about the facts, then there's no need to have a hearing. Nobody disagrees about that.
Yeah,
But where people are disagreeing about what the facts are, you have a hearing, that's how we do it. We don't do it on the papers.
yes, but if a party raises an issue as a material fact, the commission's ultimately always going to be the one deciding whether or not that warrants a hearing. Right? Just because I say there's a material fact doesn't entitle you to a hearing. That the commission will determine whether or not that raises, to that level. That has been the practice in the Washington Gas cases in the last 2, what they had done there. It was not a practice in this case, but that is the exact procedure that they went through in the 2 WGL cases that have been litigated in the last 3 or 4 years. I may go quickly then to a couple other issues. I wanted to finish with the bill stabilization adjustment, just to correct a few things. So to me, there's three issues that AOBA has brought up. I think they're very related. There's the effective rate adjustment. We call it the ERA. There is the COVID-19 regulatory asset issue, and then there are deferral bounces. They're very similar. So I'll address them as quickly as I can. I agree, these are complicated. The ERA itself is complicated. But the key really to understanding PEPCO's position here, and I think ultimately what the commission did, is that the ERA has been called different names over the years, but it has been a feature present in and approved by the commission in the last 6 rate cases, including formal case 1176. The policy then goes back over a decade. It's been consistently applied and is now an accepted practice. What it does is level sets rates and revenues prior to adding in whatever the commission says that the company should get. So the $123 million from this case, you do have to have a level set first. It's kind of like is 0.0. It takes then that 0.0 and it adds the incremental revenue on top of it. The commission adequately support its decision in the orders, reinforcing itself in order 22538, explained its decision, relied on record evidence. And second, and maybe even just as importantly, even if there is any doubt about how the commission went about this, because it's been a consistent practice, this court in Washington Gas versus the Public Service Commission, this is a 1982 decision, 450A second, explained that the commission can rely on a practice that is consistently applied in order to reach a decision.
It sounds
Sorry.
to me like what you think this fight is about is whether or not the bill stabilization adjustment, whether or not it should persist. And I don't think that's what the disagreement is. I think everybody says, yeah, sure, bill stabilization adjustment, go ahead. How do you calculate it? And that I see no explanation from the commission.
Your Honor, the bill stabilization adjustment is not on appeal before this court. It's the various mischaracterizations of what the bill stabilization results in. That is what AOBA is bringing up and what I can get to in just a second.
I agree.
A very good example for you, Your Honor, because I do not believe the BSA is at issue in this appeal. I do not.
I agree that whether or not it exists is not an issue. They were definitely saying the commission did not justify why it went with PEPCO's calculation of that over ours. It's what the dissenting commissioner said as well. And are you taking issue with that? I mean, they definitely say that. The dissenting commissioner also says that.
I believe
He
that's
said
incorrect.
that issue was not actually before the commission, even though when they when they filed their motion for reconsideration and say, you didn't explain this, and the commission doesn't say one word, actually, that's not in front of us. What's gonna tell me that they were right to ignore it silently because it wasn't actually an issue before them?
I can do my best,
Yeah, sure.
Your Honor. So there's the other two BSA issues, the ERA aside for a second. The COVID-19 regulatory asset is a very good example. So is the deferral balance. I'll start with the COVID asset. So essentially, as I mentioned, over time and as we got further away from the 2018 forecast that was used, and especially during COVID when customers in the commercial classes, most of them weren't even open for a period of time. The amount that we expected to earn versus the amount that we did earn, there were huge differences. And the way the BSA works is every month we make this filing and it shows exactly how much that difference, that gap or delta is between the two. So in this rate case, AOBA itself proposed to take a chunk, I think it was $39.7 million, take it out of the amount that was owed, because it is owed according to a commission-approved tariff, take that amount out, and over time, I think it was amortized over a period of 10 years or something like that, take that amount out, put it in base rates, so regular rates, the things you'd see on a normal tariff, customer counts and all that stuff. I'm surprised that that's an issue here because it was AOBA's proposal to do it. So it's very hard to understand why AOBA is bringing it up on appeal when it was their issue and the commission agreed with them. I think the result of it, in addition to the incremental revenue increase that was allocated to their class, could be why they say in the totality or something like that, but it was their idea. The deferral amounts, very, very similar issue. So the way the BSA tariff works, it actually shows those amounts each month. Those are amounts owed pursuant to that BSA tariff, specific to that customer class. They should not be at issue in this appeal because they're historical amounts. They have nothing to do with formal case 1176. They're just amounts owed by the subject customer class. Does that help at all?
I mean, it helps. I think I might be more confused than I was when you started, but stuff for me to go figure out. Sure.
The briefing.
I think I appreciate your point.
But there are those two amounts I think got lumped in with the argument that was made about gradualism. That is, we completely agree that the commercial classes are right now subsidizing the residential classes. So when they take in on these additional amounts and they get included in rates, of course, that has an effect on them. But that is not the same as gradualism, as we understood it, at least in terms of softening the blow as we try to get these classes closer to parity. Because of the two amounts I just spoke of, one is historical, will be recovered over time through a BSA rate. And the other was actually proposed by AOBA itself. I'd like to make one further point because I know Judge Easley, you were asking about this before. Of course, it's not the position that we want to take, but if the court were to either in whole or in part remand the case, what to do? First of all, I think for practical and then legal reasons, you would keep the rates in effect until pending further proceedings at the commission level. Practically, both AOBA, and this was pointed out in Order 22328, both AOBA and OPC testified to rate increases for the company. So to simply vacate the order and go back to ground zero is actually prejudicial to the company and also inefficient in the long run. But also I have a case for you that supports keeping rates in effect. PEPCO versus Public Service Commission 380, A second 126. It's a 1978 case. Where there were some errors in the initial order, but this court allowed rates remain in effect pending further proceedings at the commission. Now, if this were to happen and the court were to remand it in some way, I think one of the easiest ways to look at it is how I kind of teed it up in terms of the applicability of the Watergate East case. Perhaps it's the court saying to the commission, explain how this fits the exception. That would be a very simple exercise as compared to going through the fully vacating or some larger remand that would require all these evidentiary hearings. This case took 19 months to litigate. The last one took, I think, over 2 years. These are very lengthy proceedings. So that would be our position on that, Your Honor. I don't know if you had any questions for us. Okay, thank you.
Thank you very much. Mr. Gray, we'll give you a couple minutes.
Thank you. I think I just have 6 discrete points to raise. I'll start with counsel for PEPCO. First, counsel for PEPCO stated that the effective rate adjustment has gone by several different names over the years, but it's essentially a longstanding practice that's been in effect for 6 rate cases. What we're dealing with now is a new rate making regime of multi-year rate plans as opposed to traditional regulations. So the principal issue that AOBA challenged was the application of an adjustment to forecasted revenues. We didn't have that issue in traditional rate cases. So this is a different issue altogether. Now, I don't want to further complicate things, but the second point is with respect to the BSA deferral balances. There were 3 separate arguments that AOBA made as to why the deferral balances were at the level they were. The effect of the COVID epidemic was one. There was also the impact of an error that PEPCO made. That was another one. But the principal one that AOBA is challenging is the flawed methodology that PEPCO uses to calculate billing determinants. And that flawed methodology results in an overstatement of billing determinants. And that's what we're going after, a discrete piece, not the entire balance.
Did you know what portion of the balance discrepancy between the 2 experts that would account for? Is, of that 49 million, how much is going to be affected by that?
I believe about 16 million was the COVID regulatory asset, which AOBA does not challenge. I don't have the number off the top of my head, but I believe it's over $10 million. Turning to counsel for the commission, I want to raise just 4 points. One, counsel argued that this is not a contested case. First, I want to note that the commission made findings of fact and conclusions of law in its order consistent with section 2509 of the DC code with respect to actions it must take in contested cases. So it looked like a contested case. The commission treated it like one, and the commission never made that argument below and didn't make it before this court. So it's a post hoc rationale that the commission has come up with for the first time on argument. Second, I want to address counsel for the commission's statement that in not having a hearing, the commission was relying on the explicit assertions in the dispositive motions that there were no material issues of fact. I think it would be a very perverse result if any movement or any proponent of a dispositive motion was forever precluded from arguing that material issues of fact exist if its narrow motion for summary judgment on the grounds of the proponent of the application didn't meet his burden of proof was not denied. But setting that aside, this case involved a traditional rate case application and the multi-year rate case application. The dispositive motions only focused on the latter. We never argued for dismissal of the traditional test year case. So any inference that the commission may have drawn, even though we think it's wrong, would only apply to the multi-year rate application. The commission has no analysis whatsoever as to material issues of fact that would go into its consideration of the traditional rate case. There's no analysis as to why it did not adopt a one-year case versus the multi-year rate plan. Turning to the issues of fact that were identified at the legislative hearing, I just cite the court to pages 8846 to 8849 of the joint appendix. And that's an excerpt of the transcript from the legislative style hearing. And that's where counsel for OPC and AOBA both identified material issues of fact relating to the accuracy of forecasts, the prudency of investments made in calendar year 2023, which are the starting point for this case. PEPCO's ability to project costs and expenses accurately, the excessive level of PEPCO's rate of return, the transparency provisions in the reconciliation process. There's a host of material issues of fact that counsel identified in those provisions, but I want to focus on just one in particular to show why it's problematic. OPC argued in its pre-filed submissions that what PEPCO was calling its climate ready grid plan, which was the basis for the multi-year rate plan, actually, those investments did not make any material advancements towards meeting the district's climate goals, that they were just business as usual, repackaged as a climate ready grid plan. That's a material issue of fact that was noted at the evidentiary hearing that we needed further process to establish any link whatsoever between the need to make those investments and the purported benefits those investments would provide. And I didn't hear counsel for the commission even acknowledge that issue, which was a material issue. Even if the commission had grappled with those differences in the record between competing experts, you would expect to see that analysis in the record, and it's simply not there. And I'll cite the court to its decision in Washington Public Interest Organizations at 393 A. 2nd 71, where it said, perhaps paradoxically, the less equipped the court is to do the job of the agency, the more deference the reviewing court must show to the agency's authority and expert judgment. The greater the agency's obligation is to explain exactly why it chooses the particular course of action here. And that's what we don't have. Not only any type of greater obligation that the commission imposed upon itself to explain its actions, we don't have any explanation. We have an explanation of what the commission did. The last point I want to address is the remedy. We have requested vacatur because we view these orders as illegal orders that should be nullified and have no operative effect. In terms of timing, there are rates in place now under these orders that are being charged to district ratepayers. And on January 1st, those rates will increase as a result of the multi-year rate plan. The second year rates will go into effect. We acknowledge that fixing the result of the errors that the commission committed is likely to be complicated. That's precisely why AOBA and OPC argued early on in this case and throughout that the commission should hold evidentiary hearings. We saw the writing on the wall that the commission did not want to go that route and cautioned early and often not hold evidentiary hearings because otherwise we would be deprived of due process rights and have appealable issues. That's exactly what happened, and ratepayers should not be burdened with the consequences of illegal orders simply because fixing that mess is complicated. One last point, counsel for PEPCO argued that because vacating the decisions would be complicated, a more appropriate result would be to remand this case to the commission for further explanation. There's two problems with that. One, the commission needs to be sent a clear signal that it must comply with the plain language of the statutes and hold evidentiary hearings. But two, the DC Circuit in particular, when analyzing vacatur, looks at the effect of vacatur on the parties in terms of whether it would have severe consequences, but it also looks at whether the challenge decision is susceptible to being fixed on remand. And this is not a further explanation type of case that can be fixed. We're missing an entire piece of the process here. This is not a case where the commission can go back and further explain why it chose PEPCO's calculation over AOBA's. The commission has told us everything it has to tell us with respect to why it did not hold an evidentiary hearing. It simply views all issues as policy or legal issues, and there are no issues that require an evidentiary hearing.
But it is a case where even if I took all your arguments to be correct, you could have the PSC issuing what is effectively the same ruling after an evidentiary hearing and say, we've heard from all the witnesses. And like we said before, we credit the calculations, we resolve all the material disputes in Pepco's favor, and we're going to reissue the same rates. And then it will seem that the vacatur and allowing for, I suppose, some clawback and then reclaw forward. I mean, it seems that we might be putting people through a big rigmarole that's totally unnecessary if it ends up in the same place even after extra process.
Sure. So theoretically, that could happen. You could go back to July 30th, which was the date the commission of 2024, the date the commission held a legislative style hearing, and go forward from that point, have an evidentiary hearing, give parties their full due process rights. The problem with that is this is a multi-year rate plan based on projections. Those projections have now materialized. We're in the multi-year rate plan. Projections for 2025 are now actual costs. So it would not be a simple process. Again, it would be extremely complicated. Testimony would need to be updated. We would essentially have another rate case on top of the record that's been built to fill that void that's there. We submit that it is not appropriate to subject ratepayers to the consequences of this decision while all of that is playing out, simply because there is a theoretical possibility that the commission could reach the same decision. We think that process would take time, given the complications, and ratepayers should not pay rates that were established in these orders that are unsupported. With that, we will ask the court to vacate the challenged orders.
Thank you very much. Thanks to all the parties today for your arguments and your briefing. We'll take the case under advisement. Okay.